कितनी हवा चल रही है। वाह।
बच्चा एक टी शर्ट और कोट ला दे।
इसका बच्चा हो जाए।
ये गुड़िया, ये पीछे कौन सी लाइटें जल रही?
विकास भी हो, विरासत भी हो, ये जो उन्होंने समाज को जोड़ा है। आज मैं चाहूंगा जोरदार तालियों से भारत के प्रधानमंत्री का भी मैं अभिनंदन करना चाहता हूँ।
हाँ जी, शिवनंदन जी नमस्कार।
नमस्कार गुरुजी, क्या हाल है?
सर कैसे हो? दर्शन हो गए आपके।
ऑल वेल मित्तल जी, गॉड ब्लेस यू।
मित्तल जी
नमस्कार सर, नमस्कार।
कैसे हैं सर आप?
बढ़िया सर,
अनुराधा जी,
बढ़िया।
यू आर
ज्वाइन
ऑल्सो
नहीं किया अभी?
वेलकम।
थैंक यू सर, मुझे आपको वेलकम करना एक्चुअली।
गॉड ब्लेस यू। मखीजा सर ने ज्वाइन नहीं किया अभी? फोन करूं मैं?
शिवनंदन जी, आपके पास हमेशा कोई दो तीन चार अच्छी अच्छी न्यूज होती है, आप प्लीज जरा शेयर करो जब तक फॉर्मल वैसे मीटिंग स्टार्ट करते हैं।
ऑल न्यूज इज गुड न्यूज यार, मेरे पास कोई न्यूज नहीं है।
कोई न्यूज नहीं
आप
है।
बताओ।
बहुत बढ़िया, फर्स्ट क्लास, ऑल वेल इज गोइंग ऑन। आईबीपीआई इज
हम्म।
कमिंग आउट विद रेगुलेशंस एवरी क्वार्टर, यानी कि हर 10-15 दिन में एक दो तीन रेगुलेशंस नए आ जाते हैं।
वो एक ही बार
बस
में कर
उसको
देनी चाहिए,
स्टडी
ज्यादा
करो,
अच्छा
शेयर
रहेगा।
करो।
मखीजा सर भी
यस,
आ गए
मुखीजा
हैं।
जी ने ज्वाइन किया। सर वेलकम सर।
वेलकम।
प्रणाम गुरुजी।
थैंक यू सर, थैंक यू, थैंक यू।
सर गुड
गुड
आफ्टरनून
इवनिंग।
मखिया जी।
हाँ, नमस्कार जी, नमस्कार।
सर नमस्कार।
तो अभी आर वी वेटिंग फॉर सम मोर पीपल और वी आर गोइंग टू स्टार्ट?
सर सिर्फ आपकी इंतजार हो रही थी शायद।
मैंने तो ज्वाइन पहले कर लिया था, बट सिंस
गुड इवनिंग एवरीवन। सर स्टार्ट करें सर?
हाँ जी,
परवीन
हाँ जी, हाँ
सर?
जी, प्लीज। प्रवीण जी आ गए?
हाँ है ना, परवीन जी आ गए।
हाँ जी, मुखीजा जी वेलकम, नमस्कार।
नमस्कार जी, नमस्कार, थैंक यू।
यस प्लीज।
Okay. Good evening, everyone. Welcome to this session. This is going to be super special mind-blowing session, obviously because of the presence of Makhija sir, and we have other eminent speakers of Mr. Mittal sir and Manoj Kumar Anand sir as well. I request first Parveen Jain sir to just give his introductory remarks, and then we can take over the session. Parveen sir? Parveen sir?
Today topic is to
Parveen sir,
provide an institution.
आपकी आवाज नहीं आ रही है क्लियरली।
प्रवीण जी हमारे बहुत मेहनत करते हैं। 8-8 10-10 लोगों को हर 15 दिन में इकट्ठा कर लेते हैं, तो लगता है लास्ट मिनट पे थक जाते हैं।
आनंद सर आप टेक ओवर कर लेंगे, परवीन सर का
चलिए
शायद
मैं कर लेता हूँ। ओके।
Please, sir.
आई ऑन बिहाफ ऑफ आईपा एंड कीपा वेलकम्स। ये आशीष मुखीजा जी, आप सब लोगों को बताऊं, मेरे नेक्स्ट डोर नेबर हैं। आई ही एंड मी बोथ स्टे इन द्वारका। ही इज एन आईबीसी आइकॉन। तो इनके पड़ोस में रहने से मेरे को बहुत ज्यादा बेनिफिट हो जाता है, बिकॉज आई ऑल्सो, कहते हैं ना, खरबूजे को देखकर खरबूजे को रंग आ जाता है। आई ऑल्सो लर्न अ लॉट आईबीसी फ्रॉम हिम। एंड CACS IP Atul Mittal ji, our GIPA leaders Mr. Parveen, Mr. Piyush, Mr. Nipun, Mr. Rajiv, CA Vishal ji, along with my three IP sisters, Anuradha ji and Rashmi ji. I think wishfully all be present, and if they are not present, leave of absence is granted to them. With this, and I welcome my all audience also, or especially Shiv Nandan ji. और जिस मीटिंग में शिवनंदन जी आ जाते हैं, उस मीटिंग में तो चार चांद लग जाते हैं। इनफैक्ट आई हैव सीन दैट इन द फिजिकल मीटिंग विद NCLT members and NCLAT members also. तो बेसिकली जो मेरे को जो हमारा इसका टॉपिक है, इवोल्यूशन ऑफ रेजोल्यूशन प्लान्स। मैं थोड़ा सा इनिशियली इसका 2-4-5 मिनट लेके स्टार्ट कर देता हूँ, एंड उसके बाद फिर मुखीजा जी और हमारे अतुल मित्तल जी, जो हमारे ऑनरेबल लर्नर्ड स्पीकर है, दे कैन गो ऑन एडिंग इट, एंड जो बेसिक है उसके अंदर मैं बेसिक्स ले लूंगा, तो फिर एडवांस लेवल पे जो है सर, डॉक्टर साहब और मित्तल जी, they can take care for all this thing. Basically what happened is that the evaluation of registration plan is the most intricate task in whole CIRP process. COC uses their commercial wisdom. RP makes sure of legal compliances under section 30 subsection 2.
मैं कैसे किया था
And
अपने एक्सेल
and finally, I request everybody to be muted so that you can listen to me and others also. Anuradha ji, just take care. And finally, adjudicating authority evaluates it under section 31. इनफैक्ट जो हमारे लेटेस्ट बिल आया उसके अंदर सेक्शन 16A सबसेक्शन 10 के अंदर ER के ऊपर भी रिस्पॉन्सिबिलिटी डाल दी गई है रिलेटेड टू रजिस्ट्रेशन प्लान. ओके, व्हाट इवैल्यूएशन ऑफ रजिस्ट्रेशन प्लान इज, जो मैंने थोड़ा सा इसको स्टडी करा है, तो आई हैव डिवाइडेड इट इनटू 6 स्टेप्स. द फर्स्ट स्टेप is preparation of evaluation metrics, in short EM, under regulation 2HA. It provides the manner and weightage of different elements of registration plan on the basis of which COC evaluates registration plans. The EM prepared by the RP is required to be approved by the COC prior to its issuance of PRA. COC must evaluate registration plan as per evaluation metrics under regulation 39, sub-regulation 3 and sub-regulation A. Any modification in the EM is deemed to be a fresh issue and would provide a minimum 30 days time period to submit registration plan as per regulation 36, sub-regulation B, sub-regulation 5. According to regulation 39(1)B, the COC could not consider a registration plan received after the time specified in the RFRP. And okay, however, with respect to submission of registration plan, there is an honorable Supreme Court judgment of Kepraj Dharmashi versus Kotak Investment Advisors Limited, whereby they said that even they allow the late submission of registration plan also as a matter of commercial wisdom. Second, aspect is there that it has some mandatory payment obligations. The registration plan presented to the PRA is also required to comply with certain payment obligations as per section 30 subsection 2 of the code and read with regulation 38 of the CRP regulation, which are summarized here under. The registration plan should contain provisions for payment of insolvency registration process costs in priority to the payment of other debts of the corporate debtor. The payment of the debts of the operational creditor should not be less than liquidation value or distribution under section 53 subsection 1, whichever is higher. Dissenting financial creditors of at liquidation value, both are also required to be paid in priority over financial creditors who voted in favor of the resolution plan. As per regulation 39(1)AA of the RP may allow modification of the registration plan if the RP provides for the same. However, the same can only be done once according to regulation 39(1)A. Further, as per regulation 39(1)A(B), the RP may use a challenge mechanism to enable PRAs to improve their plans if the RFRP provides for the same. The second step in appraisal of registration plan by the RP is by the RP. The RP are required to analyze and ensure that whether mandatory requirements under section 30 subsection 2 of the code are complied with. All satisfied matters by higher authorities, including Honorable Supreme Courts, जो एक विदर्भा का केस था या रेनबो का केस था, वो उन्होंने यही कहा कि it is not complied with section 30 subsection 2. The third step is the placement of registration plan with the COC for its approval. The registration plans which fulfill the criteria as provided under section 30 subsection 2 of the code read with regulation 37 to 39 of are then placed before COC for further scrutiny along with details and respective orders of the NCLT pertaining to avoidance transaction जो हमारे 43, 45, 50 और 60 के अंदर होते हैं. According to regulation 39 sub-regulation 3, the COC is required to evaluate the registration plan as per the evaluation metrics. The COC is also bound to record the deliberation on the feasibility and viability of each registration plan. The fourth step is voting on the registration plan by the COC. Everybody knows that it is 2/3, 66%, and in case of tie, we need to specify the tie mechanism. The fifth step is approval of registration plan by the COC. According to section 30 subsection 4 of the code, the COC, by exercising its commercial wisdom and considering the feasibility, viability, order of priority as laid down under section 53 subsection 1 of the code and value of security interest of a secured creditor, is required to pass a resolution plan by a vote of not less than 2/3. The decision of the COC to decide on whether or not to rehabilitate the corporate debtor by means of acceptance of a particular registration plan is a decision that comes solely with the purview of the commercial wisdom of the COC. शायद जितनी भी कमर्शियल विजडम्स हैं सीओसीबी की, उनमें सबसे बड़ी यही मानी जाती है. Even in the judgment delivered by the Honorable Supreme Court in K. Sashidhar versus Indian Overseas Bank, the supremacy of the commercial wisdom of the COC has been accepted, and it has been accepted in many more cases also. As per Section 30, subsection C of the Code, read with Regulation 39, Regulation 4 of the registration plan that is passed by the COC with a majority of two-thirds, 66% in voting, is then required to be submitted to the RP at least 15 days before the maximum period of completion of CRP proceeding to NCLT with the compliance certificate in Form H. Secondly, the sixth and last step is approval of the registration plan by the Honorable NCLT. The code confers jurisdiction on the NCLT under Section 31 of the code to reform that the requirements of Section 30, subsection 2 of the code are fulfilled by the registration plan. The NCLT is required to pass an order approving the registration plan if the requirements under Section 30, subsection 2 of the code are complied with, which shall bind the corporate debtor, its employees, members, creditors, guarantors, and everybody. This is all I have. Basic concept for the registration plan. So, इसके साथ now I ask Praveen ji if you are listening us to welcome our other all guests also. मैंने तो कर ही दिया है. And then sir Mukhija ji and Mitra ji can take over and teach us the nitty gritty of pertaining to registration plan.
Sir, I think, Parveen sir, you're able to listen to us? Okay, no issues. Sir, now we will have the session from Atul Mittal sir. I'll just give a brief introduction of his. He's a qualified chartered accountant in the year 1988 and then a company secretary in 1991. And he has served, having served manufacturing industry for over 30 years, including steel, auto ancillary, packaging, garments, and FMCG sectors. He headed the corporate finance and compliance function for most part of the career. He has international stint for over 6 years in Indonesia. In 2017, he started his own consulting firm, a Mittal Business Management Consulting OPC Private Limited, providing business transformation consultancy to MSME clients. He got licensed to practice as IP in 2017. Also founded Arsh Resolution Professionals Private Limited, an IPE registered with IBBI, providing end-to-end services and consultancy in the IBC ecosystem to various stakeholders. During this period, he has completed, now this is tremendous, he has completed 11 CIRPs, 6 liquidations, 9 resolution plans, advisory to clients, and numerous other services like monitoring committee, authorized representatives, and SEBI appointed administrator. Atul sir, we give you a warm welcome to this, and we will first have your session, and then we will have Makhija sir session. So I request you to take over for now. Then I'll introduce Makhija sir, and then we'll have his session.
Sure. Thank you very much, Anuradha ji, and for the kind words. And thank you, friends. So basically, I think I will leave the legal part of the whole process to Makhija ji because he is an authority in that. What I would rather take you through is my approach as an insolvency professional. That when a IBC is allotted to you, and how do I go through the process whereby and how the evaluation is done by me as a practitioner, as an insolvency professional. And then, of course, the legal part, Manoj ji has already said, and Makhija ji will take you through the whole thing, but I will restrict myself to the practical aspect of it. So, dear friends, the moment the IBC, you become a IRP or RP, ultimate culmination, what is expected out of you as a success is the resolution plan, is the approval of resolution plan by the COC. So I will not go into the approval of resolution plan by the NCLT because ultimately it will go to NCLT and the commercial decision and other aspects will be taken care of. So now when the process starts, so there are few documents which are fundamental to creation of the resolution plan. So the first and foremost document which comes to my mind is the information memorandum. So one is the information. See, we issue Form G, and thereafter we are required to prepare the RFRP document, evaluation matrix, information memorandum, and our PUFE applications. Now, all these are input for the resolution plan. Now, whatever is prescribed in law under various sections, whether it is section 30, regulation 38, 39, everything, the contents of which are to be put up by the resolution applicant in the resolution plan need to be specified clearly in your RFRP document. So your RFRP document actually becomes the most important document. And prior to RFRP document, we also issue an expression of interest. Now that expression of interest document broadly specifies the eligibility, what you want in the resolution plan. And normally we have seen that when we prepare these documents, once these documents are prepared and adopted by the committee of creditors, it is normally not possible, or we don't do any amendment to these documents. So this is first and foremost, we should keep it in mind. Next point, what is important to me is the information memorandum. So now information memorandum is required to contain certain standard information with respect to the CD, and what are the sellable points of the CD, what are the assets, liabilities, and other aspects to be taken care of. So all those information memorandum. So preparation of information memorandum is again a very important aspect when you want to actually get a resolution plan which you can evaluate. So that becomes an important aspect of it. And in fact, now for cases where the value is more than 100 crores, there is a requirement that you have to even have a marketing strategy. So the RP, in consultation with the committee, has to have a marketing strategy as well. So all these documents, why I'm just telling you a precursor is that because invariably we end up being too much focused on the procedural part of it, but until we create, because the resolution plan, the applicant who is putting up a resolution plan, for him it is a commercial transaction. So he is looking at the commercial aspect of the business, of the value of the underlying value of the asset, even before, in addition to complying with all the requirements of the IBC. So this aspect we need to understand very clearly, because if our information in terms of the RFRP document or in terms of IM are incomplete or are inconclusive, it will become difficult for the RA to submit his resolution plan, and in turn it will become difficult for us to evaluate the resolution plan, because when we get into evaluation of resolution plan, so we are of course evaluating it in terms of the legal due diligence part of it, but also we have to evaluate it commercially. We have to see whether the plan provides for what you call it, the feasibility and viability of the plan, and also for the monitoring of the implementation of the plan after the plan is accepted. So these are certain fundamental requirement of any resolution plan, which as an RP we need to understand. And until the better we make these documents, the better becomes the probability of us to get a resolution plan per se. So the first challenge, what happens is that we as RP should get resolution plans which we can evaluate. Okay, so once these documents are provided and we get resolution plan, now the question arises how to evaluate the resolution plan. So normally what we do is that when we receive these these resolution plans, we go for one set of activity which is done is legal due diligence of these resolution plan, which can be done by the internal team or by experts. So we can take help of a law firm who can actually go through the resolution plan. And although the RA will be mentioning, I can show you in in the RFP document, normally we have a document like this.
अतुल जी, इसमें एक छोटी सी बात मैं आपसे पूछना चाहूंगा. फाइंडिंग एन
Uh-huh.
पीआर इज वेरी डिफिकल्ट. प्लीज शेयर योर
Yes.
एक्सपीरियंस हाउ यू फाइंड द गुड पीआर. Basically, let's make it a little bit interactive.
Yes, sure. So if you really want to know how to find a PRA, the day you get an assignment, your process of finding the PRA starts. Okay. Now you have to look at your email ID. You invariably get few mails from some standard PRAs who says, "Sir, whenever your Form G is getting published, please let us know. We are interested." Okay, so this is one source which comes. So here you are not doing any activity, but then maybe here you are missing out on that activity because if you ignore those the mailers what you receive in your email ID, because normally when you publish form A regarding the invitation for claims, at that stage itself the mails start coming to you regarding the PRA. So that becomes one. Secondly is the industry. So whichever industry this company belongs to, so you need to understand the industry and you need to approach some of the good players or the auditors who may be there of that industry to telling them that yeah, this company is coming there. So another catchment area what I have found very interesting is that the industry per se. Third is when you have a list of assets, you realize sometimes there is a real estate. So there could be people or investors who may be interested in real estate. The fourth kind of people are the ARCs, basically. So you need to, over a period of time, create a network wherein the moment you get an assignment, you start telling about it to your circles, to people around you, and start getting that information. Another point is that we start talking to our the COC members. So we also ask the COC members to please tell us say if it is a banker, to let us know who are other client of theirs who may be interested in this company, basically. So that is another area where we try to find these people. So this remains a preliminary sort of a situation. Sometimes some of your our IP colleagues or chartered accountant or lawyer colleagues also call up and tell us, "Ki, sir, we have a client who may be interested. Please keep us in mind." So normally I find that these kind of things happen. The biggest challenge is we are so busy, we forgot to create a list of these people, and then when actually Form G gets published, and when actually Form G gets published, so that time we should be able to send mailer to all of these people. So yes, Anandji, I hope I have answered your question. So in a typical when we say in a typical RFRP document, we create this kind of a format where we say the RP, the RA to fill in the mandatory compliances of a resolution plan. So we mention all the sections and we ask him where in the resolution plan he has mentioned it, what is the clause of the resolution plan and whether it is compliant or not. So he can put his remark. Now, based on this annexure which the RA provides to us, we go through it and then we create a due diligence report based on this. Mentioning the clause, sometimes what he says, the RA may say that he is in compliant, but then we'll see that in the language is not proper. So in that case, we would like to change the language in that case, and we will create a remark saying, "Sir, this language, there is a problem. Please modify or give a clarification for this language. So this is another thing what we normally do. And after this thing, then comes the evaluation metrics. So for each project we create a evaluation matrix based on the project parameters and based on the commercial discussion with the committee of creditors. So this evaluation matrix, one creation of this evaluation matrix itself is very, very important, and the more effort is made at the time of creating this evaluation matrix, the easier it becomes to evaluate a resolution plan, because we need to create some sort of a common denominator, so that it becomes easier for these COC members to actually understand what exactly how to bring everybody on the same platform. So another aspect what we normally follow is we try to reduce the variability in the plans. So we say, sir, for some things we say that this is the minimum price you have, so you have to put minimum this price, and you can put any price beyond it. So that there is not too much variation. Otherwise, what happens is, for one item somebody will say X price, for another item somebody may say Y price, and then for the committee of creditors it becomes really difficult to evaluate the plan. So as a RP, we need to actually go through the plan commercially, and then we have to present it in a simpler way before the committee of creditors. So we normally do a comparative analysis of the plan, which includes even comparing the net worth of the promoters who have put in the plan. What are the salient features where we believe that the plan, what are the data point or the decision points where we want the COC to look at the time of evaluation of the plan. So a comparative analysis of various resolution plan on a single sheet of paper is also presented by the RP before the committee of creditors for the purpose of evaluation of the resolution plan. And once we create this kind of a comparative analysis of all the plans, present a comparative analysis of all the plans before the committee of creditors, then we actually call one by one RA before to present their case or to present their plan before the committee of creditors, and then they go through, and then the committee of creditors ask questions, ask explanations, understand the plan. So first, we allow the resolution applicant to make a presentation before the committee of creditors, and then the committee of creditors asks question and tries to understand and see the way the RP has created that chart, comparative chart, and then the committee ticks it, and then the committee follows this process with each and every RAs one by one, and then they have then once this process is done, then we again sit together with the committee of creditors. We analyze and try to and then once this then we again sit with the committee of creditors. We try to come to a consensus on the ranking of the resolution applicants. So there is one ranking which is done as per the evaluation matrix, and there is a second ranking which is done as per the comparative analysis and the interaction with the resolution applicant. Now, based on this second ranking, we again may go for a one-to-one interaction with the resolution applicant, or the committee may decide to ask for a revised resolution plan, or the committee may ask for going ahead with a switch challenge mechanism. So that is how we take this process of evaluation of resolution plan with the committee of creditors. Of course, the legal aspect of it is given priority. So in case any plan is not compliant with the legal provisions, then definitely either we seek clarification, or if the committee decides to accept revised resolution plan, then we allow all these resolution applicants by giving them a certain period of time to, in case they want, they can submit a revised resolution plan. So this is how we do the evaluation of resolution plan along with the committee of creditors. So I will be happy to answer
Sir.
anybody's question.
Yes, sir.
Yeah.
Sir, here I also have a question. Sir, this is a general question which all of us ask, When we receive the resolution plans, should we submit all the resolution plans to the COC or only those which are compliant with IBC code?
See, we as a process submit all the plans to the COC. So the process what we adopt is normally when all the resolution plan comes, we ask all the resolution applicants to submit resolution plan by email in a password protected file. Then we call a meeting of the committee of creditors, and then one by one we ask the resolution. We induct. So these days we have online meetings. So we ask resolution applicant to come one by one, and then they tell us their password. So we open the plan before the committee of creditors, and as a due diligence process, I normally send one copy of the plan immediately to the committee member, so that it is available with the committee member. So that is the process we follow, and once these plans are opened, then we do our analysis. We take about 10-15 days to do that, and then we call the COC meeting, and then we present our analysis before the committee of creditors and take the discussion forward on the resolution plans.
So it is necessary that all the plans which we receive have to be presented to COC. Now then you give analysis that these are not compliant, these are compliant, and section 29, and then all this analysis happens. Okay. Sir, the other question is regarding the, sir.
So section 29A affidavit, normally we take it at the time of EOI itself. So we don't take it again with the resolution plan. So that analysis we already is in place with us, basically.
And sir,
I have a question, sir.
Yeah.
Sir.
Sir, technically it is provided that only the plans which are compliant should be presented to the COC. So practically and procedurally, you are suggesting the normal way of doing things, but isn't it a violation?
Sir, I think I will leave this question for Ashish Makhijaji, because it will be helpful for me also to learn. Because as practitioners, what I am doing, I'll just share. But I think he would be the right person to answer.
ब्रजेश जी मैं आपको आंसर देता हूँ. देखिए, जब सर अतुल जी आप भी एंडोर्स करोगे, जब हमारे पास प्लान आता है तो वी डोंट हैव 32 के अंदर उसको इवेल्युएट हम कर ही नहीं सकते. जब इवेल्युएट नहीं कर सकते तो देयर इज अ वेरी टाइट टाइमलाइन. जैसे मैं अभी एक मेरा रजिस्ट्रेशन प्लान हमारा आ रहा है होसिंग का के अंदर, तो वी पुट इट बिफोर द सीओसी कि भैया इसको देख लो. एंड तो इसमें आई डोंट थिंक सो देयर इज एनी वैल्यूएशन. एंड लेट मी चेक रिलेवेंट सेक्शन. सर आप आशीष जी आप बताइए, इज देयर वायलेशन?
Okay, I think this is a wonderful question which Anuradha ji has asked. I think there are two sections which are in conflict in IBC. Let's go through them. I think that's very important. Anuradha ji, may I request if you can just read section 30, subsection 3, which I think Brijesh ji is also referring to, because he says there is a legal violation. So therefore, his question is emanating from section 30, subsection 3. Anyone can read. I mean, can you read?
Sir, may I request, before we answer this question, can we take up this question in your session?
Because it's all right. It's all right. I think it's all right.
Yeah, just got a request that, Sanjeev Pandey sir also wants to speak. So once he speaks, then entire floor is for you and the entire time is for you.
I was just trying to answer the question. That's all.
Okay. So Brijesh sir will take this up in Ashish sir's session, please.
Sure. As he decided.
Sure, sir. Thank you. Parveen sir, आ गए क्या संजीव sir?
Yes,
Sanjeev sir, are you there?
Yeah.
Sanjeev Pandey ji? हाँ. Sir, आप unmuted है. You can speak, sir. Sanjeev sir?
Okay. Yeah. Good afternoon, everyone.
Yes.
So yeah, I was listening to some of the experts. So I cannot claim to be such an expert. Mr. Makhija, Mr. Mittal, they carry huge experience. I'll just add few points which come to my mind as a banker, as a person who has been involved in the drafting of regulations and all. So since this is a session for resolution plan, I would say that as a purist, I will say that plan actually, I wanted that Mr. Mittal would speak to how to construct a plan. That is one of the challenge that most of the people face, because everybody talks about plan, but what exactly is a plan? So I would say that it is more like a brownfield proposal where as Mr. Mittal rightly said, a person coming in as a resolution applicant, he is basically looking after the commercial aspect, the value in the asset. So the job of RP is to create a brochure and a IM which highlights the value, basically. So most of us as RPs, which we are failing to attract most of these PRAs in good number. Yes. So is the challenge that we are not able to highlight the value of the asset to the potential investor. That is one part. And second part, the marketing, of course, is not as aggressive as is required to be. So as regard the plan, I would only say that you start with some basic assumptions, as we do in a bank. Like when we create a proposal, we start building a proposal or a restructuring proposal, as you can say. So we start with certain assumptions. And for a brownfield project like the ones in CIRP, where you have a history and geography and background of the company before you, so it is easy to cast these assumptions. So your assumptions should not be very far away from the reality. So if you have like number of employees actually which were working for the company, then you can easily guess what would be the required number of employees in your projections. You can assess the required efficiency or the capacity utilization of the company in last 5 years and decide what will be the achievable capacity, what is actual capacity. Then the power consumption, everything is, you have some background and you can build your projections on that. So that's how you start building projections. Based on those projections and achievable sales, then you have seen that how much sales the unit may have achieved maximum. You treat that as your highest and maybe start with a conservative estimate and build on those sales estimates, profit estimates. And ultimately, when you are ready with this Excel sheet, then you build into a workable proposal, which is your resolution plan. So I have not seen many cases other than maybe the large, those dirty dozen and all, where we got some very good resolution plans. I have not seen very good plans in that sense that people don't invest time and money on these basic things, which a plan is required. And the problem is that most of our ports, NCLT, they are not bothered what you put up, because they say it's a commercial decision. I'm not going to look into whatever projection, what you did. You just pass it through COC, and I am only looking at section 30(2). But that is the challenge, that I have seen plans which are basically liquidation plans in the garb of a resolution plan. I saw one plan from one Noida company was under CIRP, where the plan was that this land, which is a industrial land, will be converted into a residential land, and then some buildings will come up and will be sold as a residential outlet. So I said, this is not a resolution plan, but somehow that got approved through NCLT. So this is, I think, as a purist, I would say, as RP, you should invest in this thing, because what will happen in future, that the COCs right now, they are only most of the time looking for recovery only. So whoever comes, they have cast a evaluation matrix also for the purpose of recovery, not for resolution. If you take my version as a purist, I would say it is basically a matrix for calculating whoever is paying upfront maximum money. Okay, so COCs are most of the time interested only in recovery, whereas the code has been created for resolution. So I would suggest that you have these kind of numbers to support your plan, so that when somebody challenges your plan in the code, you are able to explain how this plan is feasible and viable. A plan is feasible and viable only when it has the technology which can compete in the market and it has the numbers which are doable. So this is my definition of feasible and viable, which I don't see many of the courts are looking into. But what I foresee in future, that all these plans which are approved by COC for the purpose of recovery will be challenged in the court. I would like to hear from Mr. Makhija on that. So far, not many plans have been challenged. But as I can see in the future, I think that many of these plans will be challenged just because they have not resulted in maximization of value. They are not resulted in the basic objectives of the court. So I would only, in my limited whatever words I can say, that keep your numbers ready, keep your numbers sound, build a plan based on an Excel model where you have all these assumptions which you can justify to the court. Yes, sir, if I have taken the salary or a wages of a laborer like this, in actual market, it is actually like that. If I have taken the rate of a 1 unit of power as 8 rupees, actually the rate is 8 rupees in the market. So then somebody can ask you and test your plan on those numbers. Then I think you will test the test of law. You will stand that test of it. That's all I have to say. Thank you so much.
Thank you, Sanjeev sir. Thank you for your insights. Now we move on to the...
Yes, just one comment. Sanjeev ji has rightly pointed out that when we are looking at this resolution plans, so we need to, because maximization of value for all the stakeholder is the underlying situation. And if we are diligent in preparing all the basic documents, which on the basis of which the RA is preparing the resolution plan, I think we normally get a good resolution plan, and then how much as a RP we are able to work closely with the COC and educate them in terms of where to derive value and how to negotiate the resolution plans with the RA. And then I think the objective of maximizing the value can be achieved, and that is actually, the real essence.
Yeah. I totally agree. The problem is that most of the COCs, the people sent or nominated by banks in COC, they are not actually credit experts. Law requires that the COC members from bank coming into COC, they should come from credit background, they should come with some industry background, and then they are able to vet the plan. Problem is, some of the banks are putting an assistant manager with a 5 year of service in a bank and deciding a fate of a company. There lies the problem. So now the entire onus falls on the RP. But RP cannot teach you credit in 2-3 meetings, sir. So that is my problem.
But I tell you, but I tell you how to solve this. It's very simple. We believe in one thing. As a banker, he has an obligation. The person who is attending your COC meeting has an obligation to make a note to his sanctioning authority, and this sanctioning authority is very, very intelligent. Now it is up to you what kind of information you provide to the COC members, so that they can prepare a good note to their sanctioning authority. Let me tell you. So this is exactly what we have to focus on. So don't expect decision from the person who is sitting in your COC meeting, but empower him to put up a good note before his sanctioning authority.
Sir, I am the person who has seen more than 200 plans and almost 200 notes, as you are telling me. I have gone through my desk, like past, and I have this objection. Most of these plans, if they have stood test of my requirement, but somehow they got approved because there was urgency of approving the plan, and the top management also was only interested in recovery. They said, okay, how much is recovery? What is the haircut? Is it over liquidation value? These are the only tests they do. But what I am trying to say is, this future is not like that. Future, the COC or the RP will not get away with these simple things. In future, somebody will come and challenge the RP and the COC, how you approve this plan, whereas this other plan was providing a better value. So there will be some test in the court. I only want RPs to be prepared for that. That's all. Thank you.
So like we have, I think recently a case, I'm not able to recall the citation, where we have the resolution plan being reversed by Supreme Court after 4 years or 5 years of acquisition, I think. Yeah. So those kind of things are also happening, Sanjeev sir. So we don't know how future is going to be. But right now, we will allot the entire time now, leftover time, to Ashish sir. I have the pleasure of introducing him. Just give me 2 minutes, though his introduction will be little longer, but please bear with me. It's worth listening. Dr. Makhija sir is truly a polymath in the legal and financial realms with a remarkable list of accomplishments and a diverse skill set. His journey, marked by excellence in multiple professional degrees, showcases not only his intellectual prowess, but also his commitment to continuous learning and mastery. As a thought leader, his influence reaches beyond the confines of his individual expertise, resonating among insolvency practitioners, judges, bankers, and government officers. This broad reach underscores his transformative impact on the field, positioning him as a figurehead in the ever-evolving landscape of insolvency law. The fact that Dr. Makhija imparts his extensive knowledge to a wide range of professionals highlights his dedication to the dissemination of expertise. His role as a mentor and guide further emphasizes his commitment to nurturing the next generation in the intricate domain of insolvency law. Beyond his role as an educator, Dr. Makhija's influence extends through various mediums. His distinctive delivery style, which all of us will experience now. We have been experiencing one more opportunity for this. A portfolio of 14 best-selling books and meticulously researched articles collectively contribute to shaping opinions and practices in the legal community. Dr. Makhija's ongoing legacy is a living testament to the transformative power of a passion and expertise. His multifaceted contributions from academia to professional practice showcase a dedication to advancing legal domains and leaving an enduring impact on the field. It is indeed with immense pride that Dr. Ashish Makhija is presented as a luminary and a game changer in the realm of insolvency law. We welcome you, sir. Thank you so much for being part of this webinar, and we look forward to a mind-boggling session now. And the question which Brujesh sir had asked, if I may be allowed to look at section 30, subsection 3, you said, sir?
So first of all, thank you, Anuradha, and I must thank the organizer.
Makhija ji, I would like to say that next generation should be substituted by next and old generation both.
The current generation, like you people, are my colleagues. So therefore, we are trying to educate more to the next generation so that they can become better IPs. We already have that kind of an expertise. I think everyone has got that. So first of all, I must thank each one of you. And I think it is always a delight to be amongst all the fraternity members. And I must thank Mr. Manoj Anand, Mr. Parveen Jain, and all other organizers. I may not be knowing their names, but I think to run an organization like this, to organize programs like this, it takes a huge, huge effort. It's not a single person's domain. So anyhow, thank you so much for inviting me, and also organizing such programs at periodical times. I think that's also one of the important things. So updates are extremely important. So friends, before I start, and I think I answer that question, which is a very pertinent question, simple request which I always make. I do not want to speak to blank screens. Can I request everyone to please open their videos if possible? I think it's always better to see smiling faces, and it helps me in interacting in a better manner. Yeah, thank you so much. I think this is such a delight to see all my friends out here. I can now recognize many of you. Okay, thank you. Yes, I think coming back to the question, which is a very, very important question, and it has a legal answer. So therefore, what we need to follow is already decided. So it's not a new thing, but let us look at it, because my style is always that there should be a conceptual clarity. If our concepts are not clear, then probably we will be asking questions on WhatsApp. So that I do not want. So the first thing, I think I'll request Anuradha ji to just read section 30, subsection 3, which is a very important provision. Yes. Yes, ma'am. Can you read? I think you are muted.
Mike.
Sorry.
Yeah, go ahead.
Just read. Yeah, the resolution professional shall present to the Committee of Creditors for its approval such resolution plans which confirm the conditions referred to in subsection 2.
So I think if you read it plainly, now this particular subsection incumbents duty upon the RP and the use of the word shall. It says the resolution professional shall present to the Committee of Creditors for its approval. And then the next word is very important, such resolution plan. So such we can't miss. And such is also referring to the conditions which are referred to in 32. Now, 32, we know that these are the criteria. The plan must conform to these conditions, clauses number A to F, which are mentioned there, which are very serious conditions. So this is one duty. So now the big question is, supposing there are 10 plans, and out of those 10 plans, only 6 are conforming to section 32 and 4 are not conforming. So as an RP, if I go by simple plain language of section 30 subsection 3, I'm supposed to put up only 6 and not the rest of the 4. But however, the things change. Now, ma'am, can you please go to section 25 subsection 2 clause number I, which is the duty of the resolution professional. So duties of the resolution professional, subsection 2 of section 25 and clause number I. Yes, ma'am. Can you just read 25 and then straight away go to clause I?
Okay. So 25
subsection 2.
2.
Yeah.
Which clause, sir? You want me to read?
I.
Acha, this is a newly introduced clause. Yeah. This was not there earlier. Okay.
No, this was not a newly introduced. It was already there. Yes.
Okay. Okay. Invite prospective resolution applicants who fulfill such criteria as may be laid down by him with the approval of COC, having regard to the complexity and scale of operations of the business of the CD and such other conditions as may be specified by the board.
I think this is H only. Are you reading H or I?
Oh, okay. I present all resolution plans at the meeting of Committee of Creditors.
Correct.
Okay. That's
So,
why we have the.
Yeah. So 25 to I imposes a duty upon the RP, and look at the language which is used. Present all resolution plans. Here they're not talking about resolution plans which comply with the provision of section 32. The word used is all, not such. So now the question is, there is now a conflict within the IBC. 25(2)I imposes a duty, and we know that failure of a duty results in a penalty, isn't it? So 25(2)I now has to be harmoniously read with 30 subsection 3. This has already been done by the Honorable Supreme Court in Arcelor Mittal versus Satish Kumar Gupta judgment, which is of January 2018. It's an old judgment, right? We all know that. So that judgment very clearly, they also dealt with a particular aspect, and I really remember the sentence which is there in the particular judgment. It says that it should not be forgotten that a resolution professional is only to examine and confirm that each resolution plan which is provided conforms to section 30 subsection 2. Now, then they say that, look, there is no conflict between 25(2)I and section 30 subsection 3. So what they are saying is that today the legal position is, which has been decided, it says it is the duty of the RP to place all resolution plans before the committee of creditors, whether they are in compliance with provision of 32 or not. Now, the reason is this. Let's also understand why the Supreme Court said that. They said, then of course, they also added, I think Anuradhaji also mentioned in the beginning that, look, if a plan is not in conformity, as an RP, I'll prepare my report, I'll prepare my due diligence, I'll prepare my prima facie opinion, and I will give it to the COC that, look, this is not complying because of these provisions. Now, let's understand the reason why it was decided. The reason is very simple. Supposing the 4 plans which were not in compliance, but they offer a better value in terms of the amount, absolute value, in terms of the net present value, in terms of the time, in terms of many other things. But probably they are not complying with one of the provisions of section 32. Now the question is, they say, look, go back to BLRC. BLRC says it is a negotiation between the creditors and the resolution applicants. So therefore, the committee, when they're negotiating with this resolution applicant, they can say, look, your plan is much better in all other terms than the other plans, but you are not complying with this one provision where you are saying, supposing you saying will not pay the entire CR because we'll restrict it only to 1 CR. Then they can advise them. They say, look, if you change this, probably you can also, get a better, resolution. I mean, the approval can be done. So therefore, the negotiation will play a bigger role in making non-compliant plans into compliant plans also. So therefore, if the RP rejects it, then it doesn't go to COC. So that is the logic. With that logic, Supreme Court said, no, you will have to put in all the plans. So this is already decided, my dear friends. This is not a new judgment. And I think as an RP, it is our own onerous duty. It's a 4th October 2018 judgment. I think everyone knows about that. This relating to 29A, but this was a collateral issue which was also decided, a conflict between 25(2)(I) and 33. So I hope I'm clear on this because I wanted to explain the basis of that also.
Ji, one question.
Ashish, sir.
Hello.
Yeah. Go ahead, one by one, sir.
In one of my CIRP right now going on, my COC is ready to negotiate the CIRP cost. Let's say the CIRP cost is 2 crores, and say the COC is saying that you bear up to 150, I am comfortable. Do you think it's a compliant plan, or do you think this can be done?
It is not compliant because the law very clearly says that every plan must pay for the CIRP cost. And when we read it, it means 100% of the CIRP cost. It can't be restricted to a particular level. 100% of the CIRP cost has to be put in unless that commitment is there, because this is one of the conditions in Section 32. This plan is completely a non-compliant plan. It cannot be approved by the it can be rejected by the adjudicating authority. Look, we talk about commercial, wisdom. We all know that, as Manoj also mentioned, that there are a number of judgments. I think I don't have to repeat those judgments. There are hundreds of judgments now which talk about that commercial wisdom of the COC is supreme, right? Starting from K. Shashidhar, then Committee of Creditors versus Satish Kumar Gupta in SR Steel case, IBC Singapore versus Educom, Kalpraj Dhansh, which he also mentioned, that was a 2021 judgment. And then every judgment now includes that sentence, right? Every judgment includes that. But the point which Mr. Sanjeev Pandey also mentioned is extremely important to consider, because this is one of the things which also came to in one of my matters before the Allahabad bench. In Allahabad bench, what happened? One of the person's plan, the unsuccessful resolution applicant's plan, was rejected. He asked for an adjournment and the COC meeting was there, and he was asked to join that meeting. The notice for that meeting was given in the morning to him. And he had some difficulty in joining through virtual or otherwise. He said, please give me some time, which the COC also refused to give and the RP also refused to give. And ultimately, he could not present his case. There was no negotiation. His plan was rejected and the other plan was, naturally, that was approved. Now, we filed an application against the approval of that plan by, we filed an objection, right? Naturally, RP will file for the approval, and we filed an objection on behalf of the unsuccessful resolution applicant. And ultimately, the Allahabad bench, of course, that judgment has been set aside by NCLAT, but that judgment was wonderful. It was 123-page judgment when I argued that matter. And the court said that, look, commercial wisdom, we can't go, but we must see whether the principles of natural justice were followed or not. So what Mr. Pandey is saying is, Mr. Pandey is saying one step ahead, that they are saying that commercial wisdom should also be examined to a larger extent based on the experience that, look, whether the plans have been successful, companies going into liquidation, whether there has been a maximization of value or not. I would like to see those changes. I mean, I'll be very happy. But at the end of the day, we must understand, if we start bringing in the judicial wisdom to this, then the problem is then no plan will get approved. And then you see every time there will be, I would say, with due respect to the NCLT member, they will start poking their noses in every resolution plan, which is actually not the intent of this particular thing. But yes, as an RP, friends, this is a very important aspect. And I think Atul Mittalji has given you a very wide range of activities which has to be done. I can add one or two to that by saying that whenever you are holding any COC meeting, my dear friends, please make sure, A, that you follow principles of natural justice while analyzing the plans, evaluating the plans, giving opportunity to all the resolution applicants to hear them out, and everything should be done. 2, the most important, everything boils down to your minutes of the meetings. You need to prepare the minutes of the meeting detailing out what happened. I mean, you don't have to write unnecessary details. They need not be too long, but they should not be too brief. Just simply one sentence saying the committee of creditors deliberated at length on the plans. No, this is not a correct statement. You must explain what was deliberated. At least some bullet points, 3, 4 points, that on these parameters, the discussion took place. And this was the decision. So therefore, you need to elaborate. But don't elaborate too much that you have to write a 100-page book or 100-page minutes. That is also not required. That every sentence is not required to be recorded in the minutes. But your minutes are the evidence, my dear friends. They will protect you. They will protect what happened during the meeting, whether the process was followed or not. So they will protect all the decisions making and also whether the fairness of the RP, because RP's role is very important, friends. Today, it is not only managing the company, but it is like a friend, philosopher, and guide to the COC. You are a facilitator. You are trying to guide them also. Well, their competence in assessing the plan, we can't doubt it. Because the Supreme Court in Swiss ribbon says bankers in the financial creditors, committee of creditors, they have got commercial wisdom. Sorry, will not put in the operational creditors there. Because when the differentiation question also came. So these are the few aspects which need to be taken into consideration.
सर इसमें एक छोटा सा क्वेश्चन है मेरा यानी कि AR is appointed at most of the places and COC other members wants to see the video recording of the COC proceedings also. What is your opinion for that?
See, the point is, as far as the video recording is concerned and other things are concerned, typically what we generally advise the RPs is that video recordings are primarily meant for the assistance of the RPs, right? They are meant for the assistance of the RPs so that they are not missing out any point tomorrow, anything has happened or not, because you all, supposing you are an RP of 10 companies and you are holding 5 COC meetings in 7 days, you will also not remember. So therefore, video recording, you can always go back and say, who said what? So the question is, the law does not say that a video recording is to be given to any COC member. This is not provided. Unless it is specifically provided. Of course, they have got entitled to look at the list of the claimants. They have got the right to get the copies of the minutes. That's all right. But nowhere it is mentioned that video recordings can be furnished. So according to me, one should avoid giving the video recordings. Of course, someone can say, oh, what is the harm? It's a case of a transparency and disclosure. But friends, let me tell you, if you start being more transparent, I'm not saying you should not be transparent, but if you go to that extent, होता क्या है, वो 10 चीज में से कोई 2 चीज और निकल आएंगी. Which because people can read out of the context. That is a problem. So reading out of the context, hearing out of the context, any sentence they will catch and they say, isne record nahi kiya ji. So therefore, please avoid giving the video recordings. And you can also make it clear at the time of the COC meetings that these video recordings are being made for the assistance of the RP. That's all. Nothing more, nothing less.
सर इसमें एक छोटा सा क्वेश्चन हो रहा है because actually I was forwarded this problem that COC member said that what has been discussed in the COC meeting is not being reproduced in the minutes. That is what they want to reconfirm it for video recording. Question number 1. And question number 2 is that in the same company this RP is asking whenever AR is taking meeting on behalf of his class that recording should be given to me so that I should see what transpired in that meeting.
I think that's to that extent you are right, but at the end of the day, let us understand. Is it mandatory to record video recording? That's one question which we have to answer. Number 2, if I'm circulating a minute, if you have any objection, please tell me what you said. Now, if I feel as a chairperson, because I have a chairperson, because please understand, as a chairperson, you have got powers. I'm not saying you can write whatever you wish to. That is not the power. The power is you have to be reasonable. Whatever has been discussed, you should disclose it in a very, very transparent manner. That's all. But if you have to record somebody's dissent, okay, you will also do that if that is recorded. But at the end of the day, sometimes you see, if RPs are not playing a fair game, then these problems will definitely arise. In fact, similar question also came to me. And the similar question, what was that RP in one of the cases has not marked the attendance of one of the suspended directors who was present. Now one of the bankers says he was present in the video. मैंने उसकी photo देखी थी. आपने उसकी attendance नहीं लगाई. क्यों नहीं लगाई? Now that's a question which is a factual mistake which the RP probably has done. So therefore, let's avoid those and try to not to give that video recordings. That is what I can suggest. Okay, because it can get you in more in trouble otherwise. Okay.
RP can ask for AR's recording.
Sorry, RP can.
AR is after that. AR is also holding meeting with his class, and RP says that he is giving him the minutes and all this thing there, whatever transpired there, because based on instructions things move forward. Can in this as a corollary, can RP ask for the video recording of from the AR of AR meeting?
Well, typically not, because this is not a provision. Let's try to understand that. The only thing what he can ask is what you have decided. So if the minutes have been circulated informally to all the COC members, home buyers or whatever, and they have been approved and the AR submits, I think RP should take it at the face value, unless somebody objects. If somebody is objecting, then he can ask a question to the AR why it has not been done. But typically speaking, sir, what I suggest is AR and RP, well, I will not say they are husband and wife, but at least they are people in the arms, so they must go together. So if AR is holding any informal meeting, why doesn't he invite RP to be a part of it also? What is the problem? Whether RP comes or not, that's a different issue. I think we should have that kind of a trust and faith in each of us while doing it. Unless
Thank you.
COC members say कि उनको नहीं बुलाना, that's a different issue. All right. Okay, friends, let's move forward. I think these are few important judgments which I wanted to quote, because the legal aspects are extremely critical, because your resolution plans, the commercial decision can also go bad if the legal position is also not examined or taken care of. So I've got few, judgments I can mention to you. Number one, whether the first question is whether evaluation matrix, and evaluation matrix, I think my friends understand, it consists of qualitative factors and quantitative factors. Quantitative factors are typically given more weightage, right? Because weightages are to be given. I have seen in my experience that quantitative factors typically get 75 to 80% of weightage, and qualitative factors typically get 25 to 20% of the weightage. So this is the ratio in which we decide. Then in quantitative factors, we can have 1, 2, 3, 4. Generally, I've seen around 4 factors which are mentioned, and these factors are generally speaking, I think Atulji will be in a better position to say, but like say upfront cash recovery as per the plan, to the net present value of the continuing portion of the debt, 3, term of the resolution plan, in how long you are going to take, and fresh fund introduction like equity or debt for the purpose of capex and the working capital requirement. So you can give all these, you can give points to everyone. Say for upfront cash recovery, say you are giving a score of from 1 to 100, and maximum score you can give is 50, and weightage you can, within this also you can give as a weightage of 50%. Similarly, then 100% will come for the quantitative factors, and then qualitative typically would be the experience of the resolution applicant, financial strength, his background and ability to turn the distressed companies, managerial competence, technical abilities, KMPs, track record, external rating. All these are the qualitative factors which can have 20 to 25% of weightages. And then you will also, within this, you will also have weightages, and then a weighted average score will be given to everyone. So all these are to be disclosed beforehand, isn't it? Evaluation matrix decided, first it is to be decided by the COC. So first job is of the RP. As Atulji also mentioned, and I also endorse his view, that as an RP, my dear friends, whenever you are appointed, first thing you must understand the business. You may not be an expert in running a factory, like some companies into manufacturing of, say, earth moving equipment. You are not an engineer, you will not understand, but at least you must have a general idea of that business. Because unless you understand, you will not be able to create the evaluation matrix. Once you create an evaluation matrix, don't copy paste. Of course, you can take an assistance, and then you will put it to the COC, get it approved. That's the second step. Because without the approval of the COC, evaluation matrix has no meaning at all. It can be challenged. And then whenever a plan comes, you must evaluate on the basis, give a score, put it before the COC, so that in terms of number, this is the ranking first, highest one, H1, H2, or whatever way you want to do it. Now the question is whether evaluation matrix falls within the domain of the commercial wisdom of this COC, or it can also be challenged by somebody. The question has been answered by NCLAT way back in 2020, my dear friends, in a judgment of IMR Metallurgical Resources versus Ferroalloys. And this judgment is 8th June 2020. If you want, I can repeat, or maybe somebody can write it on the chat box. IMR Metallurgical Resources versus Ferroalloys. Very clearly, NCLAT mentioned that evaluation matrix also falls within the domain of the commercial wisdom. NCLTs cannot look into it. They can't add, they can't delete any portion from the evaluation matrix. So this is one of the important aspects.
So, sir, in this case, when we talk about qualitative factors, like, you said that RP should have industry knowledge before he prepares the evaluation matrix. But, sir, we see many resolution plans which are approved are taken over by SRAs who do not have any experience in the industry which they're taking over. Like, a hospital is taken over by maybe a real estate agent.
Well, you see, that is why a certain weight, because everything does not boil down on an experience. But sometimes, like supposing a company of the magnitude of Reliance, supposing they are not into a particular business, say they're not running any airlines. Now, if they bid for Jet Airways, don't you think they are the best people to do it? So all I'm saying is it all depends. So therefore, what we do is for the experience, we keep only a percentage of say 5% or 10%. That's all. The score will be very minimal. Say 5, somebody gets 5 marks, somebody gets 0 marks if he does not have experience. So 5 marks, if it makes a difference, well, that be that as it may. So,
Sir,
but have to keep.
When the objective of IBC itself is maximization of the assets, and it has to be as a going concern so that people do not lose their employment and all that. So when these kind of companies which requires a certain experience and expertise are handed over to SRAs who are not at all related to this business, don't you think it will affect the very objective of IBC itself?
Correct. See, therefore, if you see, I think Mr. S.N. Sharma is also there. In his own plan, what he has done, he has said that, look, it is a real estate project, which is an ultra luxury project. Now the person must have an experience of building, say, 100,000 square feet, FSI or something. So those people who do not have any experience, they are typically out. आपने आज तक कोई बिल्डिंग ही नहीं बनाई तो आप तो आउट.
Or they should come up with a tie-up for a person who
will with an experience. Well, naturally, his experience will definitely joint venture में आ जाएगा. Like in 29A, a person jointly in concert, isn't it? So in concert can also have an experience, and you can add that experience while calculating the numbers. So it is all dependent upon the COC, whether the COC wants to give it to a person who will not run the company. At the end of the day, it also depends whether they are going to get the money or not. And Sanjeev Pandey Saab has raised a very pertinent question, and I must answer that in the light of one of the judgments. One of the earliest judgments in 2018, one of the plans was submitted by one of the ARCs, right? Or ARCs, ARC नहीं था, ARC की backing से था, because पहले तो ARCs were not permitted, so it was backing of the ARCs. ARCs, I think I don't have to say any words. Everyone knows what kind of plans they submit. Their objective is not to run the company. In fact, in plan में लिखा हुआ था कि we will build this company and after 2 years we'll sell it to the highest bidder. Now their objective was कि आज उसको एक लेवल पे ले आओ, पैसे और मिल जाएंगे, रिकवरी हो जाएगी, 2 साल बाद अच्छी वैल्यू में बेच देंगे. आज तो ले लिया 60 करोड़ में, बाद में उसको हम 200 करोड़ में बेच देंगे. That was their idea. And the NCLT came down very heavily. Very heavily, they rejected that plan. They said, sorry, we are not going to approve it, because they went to the terms of the plan. What is whether you are trying to revive the company or not. जैसे पांडे साहब ने कहा कि resolution होना चाहिए. ऐसा नहीं कि 2 साल बाद आप कंपनी को बेच रहे हो, then that is not a resolution. वो तो it's a mere selling, then let us go in liquidation straight away. Liquidation में जो मर्जी ले जाए. We don't care about it. Anyhow, so this is one of the things. Now the second question which is related to this is that supposing an unsuccessful resolution applicant is there, naturally उसकी ego बहुत hurt होती है, and they would like to file an application objecting to the resolution plan. ये हमेशा रहता है. आप देखेंगे ज्यादा से ज्यादा ऑब्जेक्शन अनसक्सेसफुल की आती है. सपोजिंग ही ऑब्जेक्ट्स टू द स्कोर ग्रांटेड. अब देखिए बड़े फेयरनेस वाली बात आ रही है. दीज थिंग्स हैव ऑलरेडी हैपेंड. You decide a evaluation matrix. अब on the basis of the experience you are giving the marks. अब उसका कोई ऑब्जेक्टिव क्राइटेरिया तो नहीं हो सकता, बड़ा सब्जेक्टिव क्राइटेरिया होता है. सपोजिंग किसी का 8 साल का एक्सपीरियंस है, किसी का 10 साल का एक्सपीरियंस है, हाउ विल यू मार्क दैट पर्सन? यू कांट हैव टू मच ऑफ ऑब्जेक्टिविटी इन इट. नेचुरली एक को आप 10 पॉइंट दे दोगे, एक को कहोगे अच्छा यू टेक 5. थोड़ा सा सब्जेक्टिविटी तो रहेगी कहीं ना कहीं. सो ऑन दैट the person concerned challenged the score which was given to him. उसने कहा साहब ये इवैल्यूएशन मैट्रिक्स के जो ठीक है वहां तक तो ठीक है, बट जो स्कोर मेरे को दिया है वो गलत दिया है. अब देखिए अब यहाँ कमर्शियल विजडम आ रही है कि नहीं आ रही है, दैट इज अनदर थिंग. So this issue was also has been decided by the NCLAT again in one of the judgment, and I can quote that judgment. I think Rupali ji earlier mentioned that, so I'll request her to do that also once again. PNC Infratech versus Deepak Mani. PNC Infratech versus Deepak Mani, NCLAT, 22nd August 2022. This is the judgment which says that no challenge can be done by the unsuccessful resolution applicant to the score which has been granted by the evaluation matrix. The reason is it is within the commercial domain, commercial wisdom. You can't challenge. Unless, you see, if you are very unfair, you don't follow the evaluation matrix. जहां पे लिखा है कि हाईएस्ट वाले को 40 मार्क्स मिलेंगे, आपने उसको 30 दे दिए. नाउ दिस इज अनफेयर. This can be challenged under the principles of natural justice. But if you have been fair, you are able to demonstrate it. So then the court says, sorry, we will not interfere into these provisions. So this is also one of the important things which are there. Now, the third question. The COC recommends liquidation. No, plan का तो कुछ नहीं है और हमने evaluate कर लिया. We don't want to go ahead with any of the plans. And we are straight away recommending liquidation. Now, can this be challenged before the NCL and adjudicating authority, this such kind of a decision? So even on that, NCLAT has given a judgment way back in 2020. They says recommending liquidation based on evaluation of the resolution plans is also a commercial business decision, wisdom of the COC. So nobody can question it. Even in the first meeting of the COC says, हमें कुछ plan नहीं मंगाना है because we know that the company has no assets, nothing. We don't want to spend CRP cost. Send it to liquidation. 30 subsection 2, I think 33 subsection 2, it will take over any other law, any other provision. So even in the first meeting also, they can do that, but COC has to be a little fair. I mean, they must have done their due diligence. They can't take decision on the abrupt basis. They will have to justify. If it is justifiable, naturally, the courts will not interfere. So this is the third point which I wanted to mention, that recommending liquidation based on evaluation of the resolution plan is also a business. Now, the fourth point.
On your point number 2.
Yes, sir.
Evaluation matrix, of late, I was discussing that in the evaluation matrix, we will give a tie break metric that in case anything, like you said that there was a challenge in the option 2. So we will put a tie break and we will say we are giving you even 10 marks to both of you. So the CIC will always go through the tie break question.
Correct. So you will have to anticipate. I think Mr. Sharma is absolutely right. Today, we have to start anticipating what is going to happen. So tiebreaker formula, it's a good thing. You must do that, right? Or Swiss ribbon, Swiss challenge method you can adopt. कि आपस में बोलो जी open meeting कर लो, चलो आ जाओ. So all these things you will have to decide. That's what I'm saying. It can't be कि आप सब कुछ करने के बाद last में COC में decide करो कि हम जो है Swiss challenge start. No, Swiss challenge has to be mentioned in RFRP then. Everything must be disclosed beforehand. So this is the preparation or the homework which the RPs are required to do. Friends, I think I missed that judgment. Recommending liquidation based on evaluation matrix is also business decision. The judgment name is Praveen Kumar Nanda Kumar versus VSL Securities Private Limited. I'll repeat, Praveen Kumar Nanda Kumar versus VSL Securities Private Limited, NCLAT, 9th June 2020. That is the third judgment. Now coming to two more important points, then I'll conclude and we'll have a discussion. Two important points which I want to mention is, number one, supposing a negotiation has happened with one of the RAs, and COC had negotiation with, say, 4 RAs, and they said, fine, we are done with this. Now we are taking a decision. And before they take a decision, one of the RAs comes and says, okay, I want to have a renegotiation or have a further negotiation. Or there could be a second situation. Of course, COC can permit, but if they are permitting one, they will have to permit all renegotiation. That's one of the important things. You have to be fair. Or let us take another situation. COC has taken a call that, say, resolution plan number 1 is approved after the negotiation. Now the RA2, RA3, RA4, they come to know of it. Naturally, अब तो open हो गया, पता चल ही जाता है market में. And they write to the RP and the COC के साथ एक meeting और कर लो, मैं renegotiate करना चाहता हूँ, because I may be matching the bidding or I may be doing more than what he is offering. Now, supposing the COC refuses or RP refuses, can he challenge before the adjudicating authority? There is a specific decision, my dear friends, on this aspect, which says that resolution applicant has no right of renegotiation or further negotiation unless COC agrees to it. It is again within the domain of the COC. So he does not have a right. कि साहब देखो मैंने तो दोबारा बोला था, मेरे को सुना नहीं. Sorry. And in one of that cases, that's a very important case, and that is a case of NCLAT. It says Kundan Care Products versus Surya Kanta, Satpathy and others. I think Surya Kanta is all right. So Kundan Care Products versus Surya Kanta, Satpathy and others, 30th January 2020 NCLAT. In this, what had happened? In the RFRP, it was mentioned that COC will negotiate only with the top 3 RAs, not with the others. तो उन्होंने 3 को बुलाया, 3 से negotiation कर लिया. अब जो 6th वाला था, he said, why you renegotiate with me? So the NCLAT said, so therefore, please take care. I mean, put all these aspects into your RFRP document. Whatever way you want to negotiate, not negotiate, it has to be extremely clear. You must delineate all these things. So NCLAT says that, look, RFRP document very clearly says that top 3 will be negotiating. This is the approved by the COC. This falls within the commercial wisdom. No quarrel to this. 6th one now cannot come and say, I will give the higher one. Of course, if COC permits it, then it's an open game. Then they will have to permit all, isn't it? So those kind of things will be there. The last,
while on RFRP, what if something is not mentioned in RFRP and later COC says that no, let's do it this way?
See, at the end of the day, number one, if you are putting any clause, then make sure that it is not benefiting or it is not arbitrary to all other persons. Or supposing it is benefiting only one person, then it is dangerous. Otherwise, supposing you are diluting certain condition, right? Say net worth को आपने या experience को आपने 10 साल से 5 साल कर दिया, right? So, but you should give an opportunity to all of them to submit the plans again and renegotiate. तो वो थोड़ा सा fairness पूरा आपको. It can't be arbitrary change in any RFRP document. और in any case, आज की डेट में तो regulations भी कहता है कि RFRP ये जो है वो आप modify नहीं कर सकते except once or something, right? So that is also you have to follow that. Okay. Updating of the RFRP can only be done once. Then the last aspect which I wanted to mention was, I think everyone is aware of that Vijay Kumar Jain versus Standard Chartered Bank judgment of Supreme Court, right? 31st January 2019, that the suspended directors are entitled for all the documents, including notices, minutes, agendas, and they will also be present. They will not walk out at the time of when the plan has been discussed. So Vijay Kumar Jain has set the things right for all of us. But कहीं ना कहीं फिर typical practical problem आ जाती है. In one of the cases, what had happened, and this is a very recent judgment of NCLT Hyderabad bench, and it's a good judgment. What it says, one of the suspended directors is also the resolution applicant. Now the COC says कि जब plan discuss हो रहे हैं, हम negotiate कर रहे हैं with all the other RAs and including you will walk out. आप बाहर जाएंगे. तो वो बाहर गया. अब जब उसका plan approve नहीं हुआ, he went to and he objected. जो NCLT में plan रखा गया approval के लिए, he went to NCLT and said, remember that Supreme Court judgment of Vijay Kumar Jain versus Standard Chartered Bank. They threw me out because Supreme Court says I can't be thrown out of any of the CUC meeting. I'm entitled. Then they analyzed the NCLT Hyderabad bench in the latest judgment of 6th February 2024. It's a recent judgment, my dear friends. I can give you the name Prasada Raju MRV versus Vamsi Khamba Mnetu. I mean, I may not be pronouncing correctly, but I think you can find it out, right? Prasada Raju MRV versus Vamsi Khambata. 6th February 2024, NCLT Hyderabad bench. NCLT Hyderabad bench has analyzed that judgment and he says, sorry, that judgment is on a different footing altogether. It does not say if you have a conflict of interest. If you have a conflict of interest, then if the COC is asking you to go out of the meeting, they are absolutely right. This is not violating the ratio which has been laid down in Vijay Kumar Jain judgment of the Supreme Court. So two things are very important. The suspended directors will remain in the meeting if they are not the resolution applicants. Naturally, then they can hear everything. They can give their opinion. Naturally, they don't have the right to vote. But if they are also an interested party, either in one of the RAs or they are also the RAs, then naturally the other plans cannot be disclosed to them because they cannot get an advantage over the others. Otherwise, it will be like giving an advantage to the others. So to him over the others. So that cannot be done. So therefore, my dear friends, please take care. If this situation arises, then you will not be allowing the suspended directors. Otherwise, suspended directors are entitled to remain within that particular thing. One last, if we have time, can I cover one of the last judgments? Because Supreme Court, you see, has actually passed certain strictures against the NCLT also. You know? And I think most of us are aware of that judgment also. Yeah. So this is relating to NCLT principal bench. When the plans came, let's try to hear out the facts of the case. That is very important. The total claims which were filed were around 1782 crores admitted by the RP. 1800 crores, let's say that. The plan which was filed initially was 80 crores. And after negotiation 3-4 times by the COC, it went up to 129 crores. So against 1800 crores, what they are paying? 129 crores. 95% haircut. 95 or more than 90%, right? And the financial creditors were getting out of that 129 only 88 crores. Rest was given to others. So that's fine. So plan was approved. Now the plan was put before the NCLT. Along with that, there was an avoidance application which was pending. And in avoidance application, do you know how much recovery the RP sought? RP sought a recovery of 1,000 crores. तो अब एनसीएलटी के माइंड में डाउट आ गया साहब 1,000 करोड़ की रिकवरी हो रही है और एंड द पर्सन इज ऑफरिंग ओनली 129 करोड़ इसका मतलब एसेट बेस तो कुछ ज्यादा है सो देयरफॉर द वैल्यूएशन जो हुई है दैट इज नॉट करेक्ट सो दे व्हाट दे डिड सरप्राइजिंगली they wrote in the judgment without any detailed reason. They said there is no harm in looking at the expert opinion. This is this one sentence which they put in, and they said we are directing the official liquidator to re-evaluate the assets of the corporate debtor, right? So this was given to the official liquidator. Now this actually went up to the Supreme Court, and Supreme Court came down very heavily on the NCLT. They said, look, you are nobody to ask for revaluation. We have been shown the fact that nobody has objected. So you are raising this issue on your own, number one. Number two, there are 2 valuation reports already on record which show that the fair market value is roughly around 160 crores and the liquidation value is roughly around 100 crores. So you are getting more than 129 crore. We are relying upon Maharashtra seamless judgment which says that plans below the liquidation value can also be accepted by the COC. So why did you call for that without giving any reasons? So they came down heavily that you could not do that. No irregularity was there. No objection was raised. You have not cited any reasons. And just because there's a 1,000 crore recovery, it has nothing to do with it. And the plan deals with that 1,000 crore, how that 1,000 crore will be distributed. So who are you to do that? So ultimately, the thing which boiled down was the commercial wisdom is supreme, isn't it? So the powers of the judicial authorities have been curtailed to a larger extent, which is actually good because it gives a free hand to the COC, because we believe that they are the experts. अब पांडे साहब जब उस साइड पे थे तो सीओसी को बहुत डिफेंड करते थे. आज पांडे साहब इस साइड आ गए तो आप कहते हैं कि साहब जो वहां पे सीओसी मेंबर्स आते हैं उनको 2 साल का एक्सपीरियंस होता है.
नहीं सर, मेरा
I'm not
कंसर्न
commenting on you, sir. I'm just in a lighter way.
नहीं, I would like to ask a question to you. Then what will be the impact of this Delhi High Court judgment on code of conduct? Like they have asked IBBI to draft some code of conduct.
Sir,
So what will be the legal impact?
कोई लीगल
That's
इम्प्लीकेशन
what
नहीं
I
है
am
सर,
coming.
बिकॉज उसमें एक अगर आप ध्यान से पढ़ें,
अच्छा,
उसमें एक रेगुलेशन अमेंड करके उन्होंने ऑलरेडी IBBI ने डाल रखा है कि दैट COC विल फॉलो द कोड ऑफ कंडक्ट एज प्रिस्क्राइब्ड बाय द IBBI. ये एक सेंटेंस रेगुलेशन में आ गया, नहीं आया तो डाल सकते हो एक नया रेगुलेशन. सो COC और वो ले आए गाइडलाइंस, दे विल हैव टू फॉलो. सो टुडे this is absolutely right. This was actually required. This was the need of the day.
yes,
We know that
absolutely. Yeah.
जब डिस्कशन पेपर आया था, I think all of us had discussed, right? And we said that this must be brought in the code of conduct for the COC. They are the only people who are unregulated. Everyone is regulated. Rather,
Actually, I was part of the team which drafted some of code. Yes, sir.
आज
Some of
जिन्होंने
the code of
suggest
conduct.
किया था, yeah, no,
Sir,
absolutely.
RP was the most happy.
Sorry?
When this discussion paper came out to be, the RP was the most happy person that at least IBBI thought of asking to the COC for regulation.
Correct. See, the point is number one. देखिए अभी आपने भी 1-2 पॉइंट रेज किए थे मनोज जी. वाला पॉइंट, फीस कैसे मिलेगी? COC फीस नहीं देती है, कई केसेस में लास्ट मोमेंट तक फीस नहीं दे रही है. इवन फाइनेंशियल क्रेडिटर्स, बैंकर्स नहीं देने को तैयार, और फिर नेगोशिएट करते हैं कि साहब ये ले लो. अभी एक केस के अंदर, इन वन ऑफ द केसेस, वन ऑफ द RPs, वी रेंडर्ड यू सी लीगल सर्विसेज, वी रेज द बिल्स, नथिंग वाज पेड बिकॉज मनी वाज नॉट देयर. नेचुरली उसके पास पैसे नहीं है तो कहां से देगा? आज 5 साल बाद, 4 to 5 years later, he comes to me, he says, ICICI Bank or whatever bank, I don't want to name them, says that उन्होंने मेरे से negotiate किया है कि साहब instead of this we are going to pay you X amount instead of Y. तो मैंने proportionately आपकी legal fees भी reduce कर दिया. अब मैं legally बात करूं तो CRP cost, I'm entitled for the CRP cost. But frankly speaking, sir, there are no assets in the company. Liquidation में भी जाएगी तो भी कुछ नहीं मिलना. So this is one part of it, that as a COC code of conduct अगर आ जाए, so this must be one of the duties upon them, that they must look at it, how to fund these kind of things. This is very, very important. और एक पांडे साहब, मैं आपसे एक थोड़ा सा क्वेश्चन आपसे पूछना चाहता हूँ, जो मेरे को भी कई सेमिनार्स में बहुत लोगों ने पूछा है. Why the scheduled banks are afraid of lending as an interim finance? Because interim finance में आप rate of interest भी अच्छा ले सकते हो. I'm not saying you have to charge 30%, but at least you can charge 15, 16, 20%, which is much higher. Or this is the topmost super priority in a CIRP cost. So why the scheduled banks are not coming? Only private players are coming nowadays.
I'll tell you. So I have actually drafted a product for interim finance in SBI. There is a product available. If you go to SBI and you are able to convince the bank that this is something value additional for the CRP, they will do it. Problem comes that for a bank, whether it's interim finance or whatever name you come with, it's a loan for them, right? For them, it's a credit proposal. They are extending a loan to a company which is already NPA in their accounts. Only the regulation or the RBI rules allow you to keep it suspended for some time. So when they assess this, first of all, RP goes to the bank and says, I want 10 crore interim finance. तो बैंक कभी भी किसी को कोई भी लोन देगा, they have a method of assessment of the loan. What is the basis? Most of the RPs, they don't have a basis for this. Why are you asking for 10 crore? सर मेरी फीस इतनी हो गई, मेरा उसका चौकीदारी का खर्चा है, तो मेरे को, that is not the way. Nobody will lend you for that. The economic basis of interim finance is that there is a value X of the company, right? And you want to maintain this value X or maybe make it X plus something. And interim finance helps you in maintaining that value.
True.
So the RP should go to the bank with a detailed proposal supported by cash flows of the company and projected cash flows. Sir, the valuation of the company today is approximately, say, 100 rupees. If you don't pay me interim finance, I have to shut down the factory. This will go to the liquidation value, which is, say, 40 rupees. So you lose 60 rupees. That is one part. Now, if you give me another 20 rupees as interim finance, which is required as a working capital for my operations, then this will retain a value, may get you a value of 140 rupees later. This convincing will numbers. You cannot convince it by dialogue or this thing. You have to bring it into numbers, because bankers understand only numbers. So you have to support these with your valuation report, with the support of the expert. Yes, sir, this unit will continue. This has the capacity to sell its product. It has the demand in the market, and this value will, this international support in the value. That is one part. Second part, how you repay the loan.
Repay the, देखिए sir, देखिए, I think the bankers will have to understand there are two aspects are very important. I'll just take one minute.
आपने कहा कि सर हाँ.
नहीं, पहली बात है sir, number one. So what you are saying is, therefore the bankers would be willing only for a going concern company. अगर company बंद हो गई है या revive नहीं हो सकती, तो bankers will not come forward, right? Because plan कहाँ से आएगा? Number two. Now today repayment cannot be assured today. Like supposing in an SR steel. Repayment, I think the bankers will have to realize कि कोई resolution.
I'm not able to hear you, sir.
So naturally, sorry.
Voice is breaking. I'm not able to hear.
सर की वॉइस क्लियर है, शायद आपके एंड पे पांडे जी कुछ थोड़ी सी गड़बड़ है.
Anyway, I think you can readjust, sir. We'll discuss later. Yes, Atul ji, you wanted to say something. I'm sorry.
So basically, let me share my experience regarding this interim finance. So there are two ways you can ask money from the COC members. One is interim finance, and second is contribution towards CIP cost. So in one of the cases, the bankers were involved. So I had a discussion with the bankers, and it was a EPC company, and we had almost 150 crores of BGs at stake. So we said, sir, we need this to maintain this team, and we have not been able to pay them for last 6 months. Although during this period, we have been able to release almost 20 crores worth of BGs, bank guarantees. And most of the bank guarantees will be able to get in case we are able to move ahead. So they suggested, sir, instead of asking for an interim finance, you ask contribution towards CRP cost. So we made a proposal for contribution towards CRP cost, and then one of the bankers members paid. So everybody didn't pay, but at least we were able to go through that rough patch which we were supposed to do. So what I think Padeji was saying is absolutely right, that we need to have figures to convince the bankers, and I think we get support based on the case-to-case basis.
True. So I think one has to be very practical, look at the facts and circumstances of the case, and based on the experience of the RP also, here comes the experience. So you will have to make out a plan for the bankers to lend that money to them. Okay, I think we are almost at the end of the session. Or I think Anuradha, you mentioned that one of the recent judgment of Supreme Court, they set aside a plan for after 4 years. Yes. Greater Noida versus Prabhjeet Singh Soni.
ग्रेटर नोएडा.
Prabhjeet Singh Soni, okay.
सर इसमें एक क्वेश्चन मेरे को आपसे पूछना है. आपने कहा था RFRP जो है आफ्टर पर्टिकुलर अमेंडमेंट इट कांट बी इशूड ट्वाइस, बट द वर्ड रिटन देयर वाज अ मॉडिफिकेशन. तो एसआर इंडस्ट्रीज के केस में NCLT ने हैज टेकन cognizance of that modification word and said that only modification can't be done more than once, but as far as issue of form G is concerned, it can be issued. Your opinion on that, sir?
सर मैंने भी वही वर्ड बोला, आपने ध्यान से नहीं सुना. मैं अब वीडियो रिकॉर्डिंग अब आप पूरी सुन लेना. मैंने अपडेशन बोला था. अपडेशन इज पॉसिबल. Now, if you suppose with one RFRP you issue and then you update also, कोई plan नहीं आता. So naturally the second one will have to be issued. So that it's not barred. So issuing the second one is never barred. But you can update only once. Modification या updation कुछ भी बोलो.
Yeah, got it.
Yeah, word update is mentioned in the regulation. So I also mentioned that. Okay.
Sir, एक और था. Sir,
But with regard to the resolution plans and process, I don't want to comment on Ruchi Soya, where Patanjali was able to beat Adani and their quote was lower by about 1,000 crore and they still took over. Now, similarly, Patanjali has again come as a umbrella after the whole process has done in Rolta, and they have offered 80 crore more than the highest bidder. And the Bombay NCLT is ready to consider it. So it says that the whole process is meaningless. If you come with something which is much higher than the best bidder, then the COC, thank you. You are getting more money. Why are you worried? This is happening in Rolta recently.
This is unfortunate. This was not the objective where we, started with. But as a standing counsel for the official liquidator in Delhi High Court, we also face such a situation. Can you believe one of the properties was sold by the High Court and it was sold for 45 crore rupees. After 1 week, when the auction took over, within the supervision of the court, somebody came and said, my lords, I'm ready to offer 55 crores, 10 crores more. I was the official liquidators counsel, so the judge looked at me. He says, Mr. Makhija, what is your opinion? I said, my lords, more the merrier. If more money is coming, what is the problem with the official liquidator? I can't say no, because as an official liquidator, tomorrow I'll be in trouble, isn't it? So the court said, but I told the court, I said, my lords, put them to terms. So the court said, and the judge was the present acting Chief Justice of Delhi High Court, Justice Manmohan, very fantastic judge. And he said to the party, he said, you deposit 55 crore in advance within 1 week. Only then I'll consider your proposal, because your bona fide is not established otherwise. And if you don't deposit, I'll not consider. Can you believe he deposited within 7 days?
Patanjali has offered upfront
Then
payment.
the question came, the opposite side came, 45 crore वाला आ गया, कहने लगा, sir, मैंने तो पैसे दे दिए थे, मेरा क्या हुआ? कहने लगा, all right. The judge was very fair. He said, जो 55 crore offer कर रहा है, उसको बोलेंगे आपको ब्याज भी दे, क्योंकि your money will be returned and it will be returned with some interest. So therefore his money was returned in a fair manner. And then, of course, the bidding process again came back, and we sold the property ultimately for 60 CR, which was good. So 45 or 60 में आप देखिए 25% का फर्क आ गया. So therefore, I think it was worthwhile.
So now you can have a parachute bid. Even if the whole process has gone, let there be a parachute bid.
Idea is not that, but unfortunately, अब देखो sir, कई decision सिर्फ उस पे नहीं होते हैं, कई decision, you know how those are taken. So I'm not going to comment on that. Anyhow, I think, yes, Anuradha ji, you had some comments.
Yes, I had one more question, sir. Sir, this is regarding the valuation report. Sir, at which time and how this valuation report should be shared with the COC members?
अब तो guidelines change हो गई हैं. Now they are simply saying, before making the valuation report, even the valuer has to disclose the methodology before finalizing the report. So आपको valuer को बात करनी पड़ेगी, अपनी methodology explain करनी पड़ेगी. Now the question is, supposing the COC member say कि नहीं ऐसे करिए, is the valuer bound? The answer is no. The answer is no. Valuer is bound by the evaluation standards. He is not bound by he will consider the suggestion. If they are valid suggestion, he can consider it within the bounds of the law. If it is not, he will say, sorry, I cannot do that. This is the valuation.
So thankfully, the commercial wisdom does not come into picture here. Because
problem क्या हुआ, Radha ji, why this provision has been brought in? I think IBBI has explained it. People and the COC members were challenging the resolution plan on the basis of the valuation report later on. So उन्होंने कहा ये खत्म ही कर दो ना, पहले ही दिखा दो. बोला जो तुमने कमेंट देना आज ही दे दो. Let the valuer consider that, और उसमें वो disclaimer या जो डालना डाल देगा. So at least
सिर्फ मेथोडोलॉजी डिस्क्लोज करना है ना सर, वैल्यू तो नहीं डिस्क्लोज करना है ना, जब वैल्यूएशन खत्म हो जाएगा.
नहीं, नेचुरली वैल्यू तो साथ ही आएगी ना, मेथोडोलॉजी आएगी तो वैल्यू भी डिस्क्लोज होगी ना.
Sir, I add to it. Methodology is a different situation as far as value is concerned. 15 फरवरी को हमारा अमेंडमेंट आ गया था. उसके अकॉर्डिंगली आफ्टर टेकिंग confidence clause from the COC members, you have to disclose now, and not only the value but report also.
हाँ, करेक्ट.
15 फरवरी को तरफ जो अमेंडमेंट आई थी उसमें था ये.
करेक्ट. बिकॉज देखिए उसमें क्या लिखा हुआ, अगर आप प्रोविजन में ध्यान से पढ़े, उसमें लिखा है दे शैल एक्सप्लेन द मेथोडोलॉजी बीइंग अडॉप्टेड टू अराइव एट अ वैल्यूएशन. सो टू अराइव एट अ वैल्यूएशन मींस जब तक वैल्यू नहीं बताओगे तो मेथोडोलॉजी तो यूजलेस होगी ना. सो एवरीथिंग हैज टू बी डिस्क्लोज्ड. दे से डजंट मैटर. पहले एक कॉन्सेप्ट डिफरेंट था कि इसको छुपा के रखो, कॉन्फिडेंशियल रखो. नाउ दे से मेक इट ओपन so that no one can object.
Makhija ji, I request you if you can also explain where we have gone through the modification of plan after 1 year the approval of COC, that the approved plan has been modified. If you like, where RP finds that there is some ambiguity which has happened,
जो शर्मा जी का जो केस है, that was a real estate case. You know that there was a judgment by KV developer वाली जो judgment थी, कौन सी कौर थी, प्रभजीत कौर, आई एम फॉरगेटिंग द नेम,
पुनीत कौर।
पुनीत कौर वर्सेस KV developers, NCLAT, where Justice Ashok Bhushan clearly mentioned that the home buyers who have failed to submit the plan, it was due, RP was duty bound to mention them in the IM, and also the RA must have taken in care of them in the resolution plan. अब इनके केस में क्या हुआ, कुछ ऐसे क्लेम्स थे और RA ने लिखा कि साहब हम तो इसमें इनको कुछ भी नहीं देंगे, will not consider it. Now, based on KV developer, we suggested, we gave a legal opinion to Mr. Sharma saying that you can go for the amendment. So one of the amendment was brought in by way of an addendum, and that was approved by the COC. And we had filed after the resolution plan, we filed that, look, we are amending in the light of the latest judgment of this NCLAT. So if a legal position changes, naturally, otherwise plan reject ho jata, but there's no point. So we don't want that, because ultimately NCLT follow करता KV developer को, फिर हम trouble में आ जाते. So we suggested that we must do that. So please be proactive, and this is my suggestion, friends. Please do not remain as a headline reader. On a WhatsApp न्यूज आइटम बहुत आती है, पता नहीं हम कितने ग्रुप्स के मेंबर हैं, शायद मनोज जी भी होंगे, मैं भी 200 ग्रुप्स का मेंबर हूं आज की डेट में, जो सिर्फ IBC पे बात करते हैं. अतुल जी भी होंगे, शर्मा जी भी होंगे, ब्रिजेश जी भी होंगे, अनुराधा जी भी होंगी, सब होंगे. और सब में वही एक एक न्यूज सब फोरम्स पे आ जाती है, और हम उसको पढ़ के समझ लेते हैं कि सब बड़ा हमने सीख लिया. फ्रेंड्स, प्लीज curtail that habit. Read that judgment. If you read that judgment ना, मैं अभी आपको 2 एग्जाम्पल दे देता हूँ. चाहे आप बड़े से बड़ी कोई कंपनी ले लीजिए, चाहे SCC ले लो, चाहे IBC लाइव ले लो, चाहे लाइव लॉ ले लो, देयर हेडिंग्स आर टोटली रॉन्ग, टोटली डिसेप्टिव. और जजमेंट में नॉट लिखा हुआ, ऊपर नॉट ही गायब है, तो मीनिंग ही चेंज हो गया. So therefore, headlines can be very superficial. Let's not go into that. Let's go to the judgment. I think that's my humble request with folded hands to all the RPs. Right? So,
सर एक
सर
क्वेश्चन
हम
आया
उसके लिए आपको बार बार बुला लिया करेंगे इस प्लेटफॉर्म पे. हम सर वो पढ़ के भी हमारे को इतनी समझ नहीं आती जितनी अच्छी तरीके से आप हमारे को समझा देते हैं. And we take a promise from you, whenever we call you, you please spare your precious time for us.
yeah, definitely. In fact, evaluation.
Sunil sir, you want to ask?
Yeah, I am from Cochin, madam. Can I ask one question?
Yes, sir.
Sir, Makija sir.
Yes, sir. सर एक चीज है सुनील जी, आप अपनी फोटो दिखाएंगे 5 सेकंड. Can you show your video?
Sir, the issue here is I'm in the bank only.
अच्छा चलो, doesn't matter. Okay, go ahead, sir. Go ahead.
Sir, my doubt is, suppose a company account, if the resolution plan is already approved,
right,
and we have received certain amount, and the company is already gone, and subsequent to that, we are going to file application against the personal guarantors.
Right.
So in that case, whether we have to continue the account in the same company name, or we have to close the company name, and whether we can add the personal guarantor's name there, because normally in banks and all, the loan is taken by the principal borrower name only will be there. And when the resolution is over, means that company we cannot do anything. So again, we are continuing the same name, and we cannot mention the personal guarantor's name. So that is actually, it is an issue. And question is happening here, and whether we can change it, whether we can make the personal guarantor's name there. So what is your answer, sir?
Sir, my answer is very simple. As far as the money you lent it to the corporate debtor, your client is not the personal guarantor. The money was given to the company, to the corporate debtor. So naturally, if the account becomes an NPA, you put it into a memorandum account, isn't it? You don't keep on charging the interest because it becomes an NPA. So therefore, keep that account as it is in the name of the corporate debtor. Whatever money you have received, that's fine. And rest of the money will keep on showing as a memorandum account. And then naturally, you can file against the personal guarantors into NCLT, or you can proceed against them in DRT. Wherever you wish to do that, you can do that. But keep that account, company's account, in your bank.
So there is no need to change it.
Sir, you can't change it because you did not lend the money to them. The question is, आपने पैसा किसको दिया था? You gave money only to the company.
agreed, sir. But suppose in liquidation, if the company is finally selling all the assets and dissolution is there filed by the liquidation, we can do that also. Whether we can continue the same name, company name.
Well, you will have to write down so and so company within bracket in liquidation. So factual position will come over. But you will have to keep that as account as a memorandum account till the time you get the money from the personal guy. Sanjeev Pandey is not there. Probably he was in a better position to answer that.
Yeah,
Okay.
actually, I missed the question. Can you repeat?
Sir, his question is that they lent money to the company. Mr. Sunil Nair, can you just mute yourself? I think there's some background noises were coming. Okay. And so his question was that they lent the money to the CD. CD ka resolution plan approve ho gaya. So instead of say 50 crore, they got 30 crores. Now 20 crore balance, naturally the company is not going to pay. So they say whether we should replace the name of the company with the name of the personal guarantors या हम उसी कंपनी के नाम में अकाउंट अभी खाता खुला रखें. That was his question.
हाँ नहीं, they can keep. Basically बैंक में दो तरह के खाते होते हैं. One is like return of accounts, where you maintain it as a OCA advance under a collection account. And normally in such cases where we get some recovery in the resolution plan, remaining amount is written off. At the same time, if you want to go out against the guarantor, you need some bank support, some document to show that there is a claim.
Correct.
So I would say that keep it under OCA and keep it in the company's name and show it as a claim against the guarantor. We claimed the guarantor, so that is suffice.
Even if the company is liquidated, still it can continue and claim against the personal guarantor can continue.
Yeah,
I think
keep some entry in the bank books of the bank so that you can support that in the court.
I was looking from the legal perspective because you have not lent the money to the personal guarantor. Naturally, his cannot be replaced. That was my legal perspective.
Yes.
Okay.
सर इसमें एक चीज ऐड करना चाहूंगा, जब कंपनी अब लिक्विडेट करते हैं तो हमारे को बैंक अकाउंट सारे क्लोज करने पड़ते हैं.
नहीं सर, वो OCA में अकाउंट खुला रहता है. एडवांस एंड कलेक्शन यू कैन कीप इट ओपन. It is a return of account of the balance sheet, but you can keep it as an account.
Sir, I'm saying from CD perspective, our liquidation application for जब हम dissolution की application फाइल करते हैं liquidation के बाद, the first paramount question NCLT का यही होता है कि अपने अकाउंट सारे बंद करे कि नहीं करे. इनफैक्ट आई रिमेंबर कि अब कोई छोटा मोटा खर्चा होता है तो लिक्विडेटर अपने अकाउंट पे ले लेता है उसको, फंड्स होते हैं या पैसे होते हैं ले लेता है.
सर उसमें एक ही चैलेंज है, अभी तक RBI की जो गाइडलाइंस हैं, they don't even clear you from willful default and all that. कि आपका resolution plan approve हो गया, company is no more a willful defaulter, it is under a new management. Still, the willful defaulter tag will continue in the company because they say that both the guarantors and the company and director, they are continue to be willful defaulters. So that is I think missing part from RBI. They have not yet distinguished the corporate and the people attached to that. So both are considered defaulters even after resolution.
उसमें एक और भी ना, सपोजिंग प्लान अप्रूव हो गया लेकिन इंप्लीमेंट नहीं हुआ प्रॉपर, तो वापस स्टेट आ जाएगा ना. तो एक डिफरेंट एस्पेक्ट है. आई एग्री इन लिक्विडेशन एवरी अकाउंट इज टू बी क्लोज, बट मनोज जी लेट्स अंडरस्टैंड फ्रॉम द बैंक्स पर्सपेक्टिव. बैंक भी आपका अकाउंट तो क्लोज कर देगा, बट अपनी बुक्स ऑफ अकाउंट्स में वो जैसे सर बता रहे हैं कि दे विल कीप इट इन अ रिटन ऑफ अकाउंट्स. वो एक मेमोरेंडम अकाउंट होता है व्हिच डज नॉट कम इनटू देयर लेजर अकाउंट्स.
बैलेंस शीट में नहीं है.
बैलेंस शीट में नहीं आता.
Yeah, secondly as a liquidator,
चैट बॉक्स में आया हुआ है.
as a liquidator, my obligation is to close my liquidation account and any other current account, where a credit balance is there. But I cannot go and ask the debtors, the creditors who have not received their money, to close my account with them, basically.
That is also a valid point. That is also valid.
True.
Yeah.
There's a question box by Rachna. Sir, resolution plan can be revised only once. Can the financials be changed any number of times?
मैडम ये जो resolution plan can be changed only once, ये कोई practical नहीं है. And I think we have seen the number of negotiations, number of changes taking place. कई बार NCLT भी बोल देता है कि COC to consider. अभी सुप्रीम कोर्ट ने ही बोल दिया इसी लेटेस्ट जजमेंट में प्रभजीत वाले में. So I think we have to look at from the more practical point of view, where negotiations can happen and the plans can keep on changing. ऐसी बात नहीं है. They can. Supposing अब देखिए एक प्लान आया, आपने 2 कंप्लायंस पॉइंट आउट करी, 10 कंप्लायंस करी, उसने 10 की बजाय 2 करी और प्लान चेंज करे भैया, तो एक बार तो चेंज हो गया. अब नेक्स्ट टाइम ही हैज टू चेंज 8 more because you are still insisting. तो सेकंड टाइम तो ऑटोमेटिक चेंज होगा ही होगा. So I think this is not a practical aspect. It is to be taken with a little pinch of salt. Right?
So
practically,
it is directory rather than mandatory.
So practically the way we do. Sorry,
No.
practically what we do is we ask for clarification, and then once all the clarifications are there, then we give them one chance to change the plan.
In that,
So
right.
when we give that chance, we call a COC meeting and then say that now if you miss out anything, then we will not get any chance to change, basically.
Good point. Good point. To cover up the legal side also, it's यही तो एक ही बार clarification की बात मांगी. Good
Yeah.
point. Sanjeev ji,
You know,
you were saying.
I was trying to say is that so far as I understand, the distribution is still a commercial decision. Although
Right.
IBBI was having some calibration on that to make it a judicial decision. What is your say about that?
Sorry, sir. एक बार दोबारा repeat करें, sir.
Distribution of funds under a resolution plan. One part is the amount
Right.
of the plan, and what is the distribution to the members in the resolution plan?
Distribution, sir.
53 section.
Distribution is naturally number one, the commercial wisdom, but it's also a legal question because this needs to take care of section 32B. बस 32B का एक प्रॉब्लम है जो इशू आ जाता है, राइट? अब किसी का सिक्योरिटी इंटरेस्ट कितना है, उसकी प्रायोरिटी कहाँ पे है? अब लाइक इन ग्रेटर नोएडा वर्सेस प्रभजीत सिंह सोनी, one important statement which has been made, which is going to affect all the real estate projects. Supreme Court says Greater Noida is a secured creditor. और एक सोनभद्रा की जजमेंट कहती है ऑपरेशनल क्रेडिटर. तो अब ये सिक्योर्ड ऑपरेशनल हो गया. अब सिक्योर्ड ऑपरेशनल हो गया तो इसकी प्रायोरिटी कहाँ है? 53(1)(b) में है कि 53(1)(e) में है? अब ये कोई क्लैरिफाई नहीं करता क्योंकि द वर्ड विच इज यूज्ड इन 53(1)(b) सिक्योर्ड क्रेडिटर, वहां पे फाइनेंशियल नहीं लिखा हुआ. एंड मैं थक गया हूं सर एमसीओ को बोल बोल के कि इसको सिक्योर्ड फाइनेंशियल कर दो 53(1)(b) में, सारा सोल्यूशन हो जाएगा. आई डोंट नो व्हाई दे आर नॉट अमेंडिंग द लॉ. So this is again going to create a confusion.
Yes.
So therefore, the Supreme Court has sent it back to the COC after 4 years. Can you imagine, sir?
Yes.
After 4 years, the plan was approved. So these are the things. I think there are one or two questions. Sarika Chen says.
Sarika Chen. Yes, sir. Can we submit asset memorandum without valuation report as valuers are delaying the valuation report?
Well, valuers, you see, at the end of the day, asset memorandum has to include the value, isn't it? And naturally, it has to base on the valuation report, isn't it? I think Atul ji and Manoj ji, they are experienced IPs. I think they can better.
सर हम ये करते हैं, मैं इनका आंसर भी लिख दिया था. वी राइट इट एज अ बुक वैल्यू कि हम जो एसेट मेमोरेंडम वेरिएशन करके दे रहे हैं, इट इज बेस्ड ऑन बुक वैल्यू. और कल को लेटर ऑन जब वैल्यूएशन रिपोर्ट आ जाती है तो वी डू रिवाइज दैट एसेट मेमोरेंडम. अतुल जी, योर ओपिनियन.
Yeah, so basically when we prepare the asset memorandum, so it is done at the very early stage. One asset memorandum is prepared in case of liquidation only. So in case of CRP, there is no asset memorandum as such. So when we are making that asset memorandum in liquidation, invariably we have the valuation report under CIRP. So if that valuation report is available, so then it is there. Else we go by the book value, means or our own estimate. So that's both are okay with us.
Right. I think that's the best solution here. Right. Okay, friends. Any other question?
Problem which people are facing, there are two questions which are coming to me also. That certain RPs have suo moto appropriated the bid amount or EMDs. Point number one. And point number two is that in many cases, what is happening is that, like Pandey sir had come up with something that we should make a comprehensive information memorandum and everything. In my one case, you know that I do not have even a single voucher. I do not only have a approved resolution plan from COC, I have a PUFE application of 250 crores and not even a single voucher from the company. But this comes that we have a resolution achieved somehow, but there is no PUFE report coming up. How do we deal with such situations?
No PUFE report coming up means, I'm sorry?
Because there are no books of accounts. I am able to achieve a resolution in one case which you are also involved. There is a PUFE report because I somehow managed. And the plan is also approved without any data, without any record with me. But in cases where I can achieve a plan approval, but there is no PUFE report, how do I deal with it?
As far as the...
Like in Bhushan Steel, it happened that it came after the plan approval.
As far as forensic report is concerned, typically, naturally, the books of accounts have to be examined. If the books of accounts are not there, you have to gather the financial information from varied sources. I don't know how many of us are writing to income tax department. How many of us are writing to PF department to give the employees data? How many of us are writing to GST department to get the copies of the returns if the promoters are not cooperating? You have got powers, my dear friend. Write down to all these authorities. Get the as much as document bank statements तो मिल ही जाएंगी आपको कोई difficulty है ही नहीं. So and the bankers who are the COC members, in fact, it is written in one of the regulations that they have to share all the valuation reports. They have to share all the stock reports, stock audit reports, जितना भी data उनके पास होता है. You are only thing you have to ask them. They are not going to submit on their own. So collect as much as data. Based on the transactions in the bank account, you can still form an opinion as far as the forensic, the PUFA transactions are concerned. So जो भी बेसिक है उसी पे कर दीजिए, वो तो करना ही पड़ेगा.
सर इसमें मैं बताता हूँ, आजकल हम लोग जो प्रैक्टिकली करते हैं, हमारे शिवनंदन जी सीनियर हो गए हैं, हम थोड़े से यंग और जूनियर हैं. हर चीज ऑनलाइन अवेलेबल है. जीएसटी के पोर्टल पे जाओ, इनकम टैक्स के पोर्टल पे जाओ, आपको इनफैक्ट एक कंपनी के अंदर मैंने भी, आई वाज एन आरपी देयर, मैंने इनकम टैक्स रिफंड से ही उसका सारा सीआरपी चला दिया. When I went to the portal, I found that so many refunds are pending there.
The plan is approved, but PUFA report आई नहीं हुई, क्या करोगे?
सर PUFA report तो not mandatory. अगर आप नहीं आती आपके पास तो you use write it in your COC that because of these reasons I'm not able to get forensic audit done. That is unto it.
No, I think the obligation on the RP is to have a determination. Not a PUFA report, means transaction audit report or not. The question what you have to place before the COC is your determination. I tell you, in one of my matters, we didn't have any record, but based on the facts, we could file a Section 66 application on 2-3 matters which were apparent from the facts and circumstances. Without even a single record, I didn't have a transaction audit report, but I filed my Section 66 application and placed the determination before the NCL, before the COC, and took the process forward.
Atul ji is absolutely right, friends. We have like Brijesh ji, Atul ji, I think and Sharma ji, there are so many experienced people are there. Don't you think कि हम सिर्फ जो है लिफाफा देख के खत का मजमून पहचान लेते हैं कि कहाँ क्या हुआ होगा? तो थोड़ी सी ट्रांजेक्शन कहीं ना कहीं मिल जाती हैं तो हम 1+1 कर लेते हैं. I think this is something which you have to do and analyze. Opinion बनाओ, determine करो और file कर दो, whatever way it is to be done.
In my case also, sir, I filed 66 application without any auditor's report.
Right.
Even after I think second COC I filed.
Right.
And now the director, he is so advanced that for those plots he transferred to some dummy company, and I extracted record from the ROC and could find out that it's a dummy company. Now I have got the stay order from NCLT, status quo. Now that person has initiated CIRP in that dummy company. And sir, I have filed 65 application immediately.
Immediately, is a frivolous.
Frivolous. So at least efforts तो हमें करने ही पड़ेंगे सर. बाकी तो judicial authority और बहुत, जैसा कि members are saying, there are so many sources to get the records.
Correct. वो सर एक investigative hat तो पहननी पड़ती है.
बिल्कुल.
One query, but in one of my case, company is partner in one partnership firm, holding 99% share holding in that in the share of profits of the firm. In that firm,
so just a sec, sir. Company is holding 99% share in a partnership firm.
Yes, sir.
Right. Okay.
In that firm, company is having X amount as capital, and X plus Y is withdrawn by other partners holding 1% share.
Right.
Like other partners are having minus contribution capital.
Right.
So will we fall under ambit of Section 66?
See, naturally, if the money has been taken without any agreement, without any purpose, without anything, right? So naturally, you'll have to see whether if it is within a period of look back period, whether it falls in a preferential transaction, or if it is a clear-cut case of a diversion of money, then obviously it will fit under the circumstances of fraudulent transactions under 66(1), fraudulent trading. So naturally, you'll have to take a call. But only thing is, in fraudulent trading, based on a Supreme Court judgment, you can make only the promoters and the persons who are in the management of the company as parties. You can't make a third party under 66. So that is taken.
That 1% basically promoters only, basically.
Promoters हैं तो फिर 66 बनता है. मतलब देखिए जो आप facts बता रहे हैं, बाकी तो डिटेल में देख के I think one can give an opinion on that.
Basically, the persons holding 1% share has overdrawn capital by Y amount.
So looks to be
Definitely.
looks
पर
to
नेगेटिव कैपिटल है ना तो बनता ही है.
Yes,
पक्का
yes,
बनता है जी. You filed 66. He says that capital is negative. How you can have a allow negative capital?
And sir, one more thing, some amount is advanced for capital goods, and that account is scared off by debiting to P&L account, by debiting to discount account.
Okay.
Very heavy amount. Will it also be fall under?
Good question. And I think I argued for this matter before the Chennai bench. There is an NCLAT judgment. Writing off or adjusting the accounts is also a case of avoidance transaction. It can fall under fraudulent transaction. I have argued this matter before Chennai bench. Order is reserved, but I based my argument on the basis of NCLAT. There are 2 NCLAT judgments on this. So if you want those judgments, connect with me. I'll share those judgments with you.
Please.
इसमें सर एक सुप्रीम कोर्ट की जजमेंट भी आई है पूजा बेरी के केस पे. यू कैन लुक इनटू दैट आल्सो. उसमें भी फ्रॉडुलेंट ट्रांजैक्शंस को उन्होंने ऐसे कवर करा है एंड दैट मैटर वेंट अप टू सुप्रीम कोर्ट. यू कैन लुक दैट आल्सो.
नहीं उसमें राइटिंग ऑफ भी है क्या?
हाँ जी.
अच्छा ओके.
वो राइटिंग ऑफ नहीं है, स्केयर ऑफ जजमेंट है वो.
हाँ वो स्क्वायर है.
मे बी स्केयर ऑफ होगा. देन आई बी
इनका केस तो स्क्वायर ऑफ वाला ही है अपना जो ये बोल रहे हैं भूपेंद्र जी. But writing off is also considered as fraudulent transaction. Okay, I think we are at the end of the session now. We had a good session. मेरी मनोज जी और प्रवीण जी, अनुराधा जी आपसे रिक्वेस्ट है. अभी एक सुप्रीम कोर्ट की जजमेंट ये ग्रेटर नोएडा वाली तो ठीक है, वन कैन रीड इट एंड अंडरस्टैंड. इसके अलावा एक सेट ऑफ क्लेम के ऊपर एक जस्टिस संजीव खन्ना ने जजमेंट दिया 3 जनवरी की. राइट, वो एयरटेल या एयरसेल की जजमेंट है. प्लीज मार्क माई वर्ड्स फ्रेंड्स, मैं जजमेंट 5 बार पढ़ा हूँ तब जाके मेरी समझ में आई है कि वो जज साहब कहना क्या चाहते हैं. It's such a complicated written judgment on these you see set of claims in CIRP. It's a wonderful judgment. I think if you can hold a session, I will be ready to come. Let's debate it, let's discuss it, let's understand that judgment.
The set off of the guarantee amount.
नहीं सर, सेट ऑफ गारंटी या कुछ भी, जैसे सपोजिंग एक क्रेडिटर से पैसे लेने हैं, एक को देने हैं, मतलब सेम डेटर क्रेडिटर का रिलेशन है. कैन यू सेट ऑफ? बिकॉज आरपी तो कहता है कि अपना क्लेम फाइल कर दो, जो आपने लेना है, जो मैंने लेना है वो तो मैं आपसे रिकवर करूंगा ही करूंगा. सो दिस जज हैज कंसिडर्ड, because in liquidation में there is a regulation 29 in liquidation regulation which says mutual credit and set off, but this sentence is missing in CIRB. So he has dealt it in a very greater detail, and he says there are 5 types of set offs: equitable set offs, statutory set off, common law set off, contractual set off, insolvency set off. Insolvency set off को अलग category बनाया, which was a surprise to.
It will be nice if they can conduct a.
I think
सर हम कर लेंगे, you know.
We will be honored, sir.
सर नहीं, we request since he has enlightening us. सर आप नेक्स्ट वीक के अंदर मैं आपसे बात कर लूंगा जब भी आपके पास टाइम होगा. एक इसके ऊपर, एक नोएडा वाली जजमेंट के ऊपर, दोनों सर बड़ी
कर लेंगे,
दोनों कर लेंगे, नोएडा वाली की और ये इसके ऊपर भी कर लेंगे. वी शैल हैव अ सेशन ऑन इट बिकॉज जो अभी आपने बताया
रिसेंटली मखीजा सर 4-5 दिन पहले उसके ऊपर भी आई है रियल एस्टेट में, दैट यू आर ए स्पेकुलेटर. एनक्लैट की जजमेंट है भूषण सर की, वो भी वी विल लाइक टू बी इनलाइटेंड बिकॉज वी हैव बीन एडमिटिंग क्लेम्स ऑफ इन्वेस्टर्स.
देखो, इफ यू आस्क मी, I always read Supreme Court judgments more than any other judgments, क्योंकि आप एनक्लैट का ट्रेंड देख लो. मैं I no comments to those members, they are fantastic persons and I think we respect those, but 70 to 80% of the judgments are overturned.
58F की उन्होंने भूषण सर ने इंटरप्रिटेशन दी है और बोला कि if you are a speculative investor,
right,
you are not a financial creditor.
Right. I think let's leave it at that, sir. So I think we have already.
शिवनंदन जी, हम नेक्स्ट मीटिंग करेंगे, सर के ऊपर छोड़ देंगे कौन सी जजमेंट ये हमारे को पढ़ाना चाहते हैं. वी शैल हैव अ टॉपिक की लेटेस्ट जजमेंट ऑन आईबीसी. और इस मीटिंग को आप अनुराधा जी से परमिशन लेके आप को होस्ट करना, सो दैट वी हैव अ लवली इंटरेक्शन विद ईच अदर. एंड सर, मैं मुखिजा जी आपसे बात करके वी शैल फिक्स अप एज पर योर कन्वीनियंस इन द नेक्स्ट वीक.
Absolutely. Thank you so much.
Sir, thank you so much. Thank you for this enlightening session. And we would love to have you again, sir. It will be an honor to host you every time you come. You're ready to come. I would like Manoj Kumar Anand, sir, to give a vote of thanks to all the speakers.
थैंक यू.
Yeah.
थैंक यू वेरी मच. देखिए, मैं आपको एक बात बताना चाहता हूँ पर्सनली, कि हमारे यहाँ पे जितने आईपीएस बने हुए हैं ना, स्पेशली इन दिल्ली एनसीआर, काफी सारे आईपीएस इन्हीं से पढ़ के इंस्टीट्यूट के अंदर बने हैं. बिकॉज ही वाज, आई एम टॉकिंग अबाउट द 3-4 years ago व्हेन ही वाज
मैं भी हूँ.
टीचिंग अस दिस. आप भी हो. चलिए,
कोरोना में
ये तो
पढ़ने
एक
के बाद भी इन्हीं से पढ़ रहे हैं.
लाइव एग्जांपल हो गया. हाँ, मैं वही शिवनंदन जी की बात कर रहा था कि जनरली होता है कि जो फैकल्टी होती है वो एक बार एग्जाम क्लियर होने के बाद खत्म हो जाती है. लेकिन सर का हमारे साथ ऐसा रिलेशन है कि दैट वी आर लर्निंग फ्रॉम हिम, और शायद आने वाली पूरी लाइफ इनसे हम सीखते रहेंगे. जैसे आज इन्होंने सिखाया हमारे को, और एकदम ऐड हो गया कि हम नेक्स्ट वीक के लिए इनको बुक कर रहे हैं. और वी आर रियली रियली थैंकफुल टू यू सर. एंड इनफैक्ट वी आर ब्लेस्ड एंड वी आर ऑनर्ड दैट वी हैव ए पीपल लाइक अस इन आवर सर्कल, जिनको हम जब भी कहते हैं सिखाने के लिए तैयार रहते हैं. और दे लव टू टीच अस आल्सो. और आपका सर जो सिखाने का स्टाइल भी है ना, दैट इज मार्वलस. दैट इज एब्सोल्युटली मार्वलस. आप अपनी बात को कैसे कन्वे करते हैं जो हमारे दिमाग के अंदर एकदम घुस जाती है. दैट इज द बिगेस्ट पार्ट ऑन योर पार्ट. दैट इज नॉट सेट कि आप यानी कि सारी की सारी जजमेंट पढ़ना चाहिए. हमने कहा जी हम पढ़ेंगे नहीं, हम आपके मुंह से सुन के अपने दिमाग के अंदर डालेंगे.
सर, conceptual clarity सर दे सकते हैं.
Yeah, and Atul ji also, he shared a lot of his experience today. मैं सर एक बात थोड़ी सी इसके अंदर अतुल जी थोड़ी सी ऐड करना चाहूंगा कि बिकॉज इट माइट हैव हैपेंड दैट यू मेनी अ टाइम्स वी पीपल फील प्रैक्टिकली दैट गेटिंग पीआर इज वेरी डिफिकल्ट. If we compare this situation in the Europe and some of the developed countries, they have institutionalized all these things there. We need to develop that market in India also there. And so if we have that sort of institutionalization in India, that will go a very, very, very long way, as far as getting PR is concerned. क्योंकि मेरे आईपी ब्रदर जितने भी यहाँ पे होंगे, सब लोग ये फील करते होंगे कि गेटिंग पीआर इज हुरिकन टास्क. और फिर उसके लिए पीआरए के लिए वो एक पीआरए जो आपको वैल्यूएशन देता है, जो दूसरा पीआरए जैसे शिवनंदन जी ने बताया, सर ने बताया, अल्टीमेट ऑब्जेक्टिव इज मैक्सिमाइजेशन. तो उस मैक्सिमाइजेशन के अंदर बहुत सारा फर्क आ जाता है. तो लेट आवर regulator and maybe our agencies look into our this suggestion also, that let some institutionalization be done, because in that case, sir, आप कुछ कहना चाहते हैं? आशीष जी, प्लीज कैरी ऑन. Please add to what I'm saying.
No, I don't want to say anything. I'm okay with that.
सर, आप
If
वोट ऑफ थैंक्स
anyone-
प्रपोज कर रहे हैं तो वो सुन रहे हैं.
नहीं, देखिए, हमारा इंटरेक्टिव सेशन है. मैं हमेशा ये कहता हूं कि हमारा सेशन जब इंटरेक्टिव होता है तभी अच्छा लगता है. चलिए, बिफोर वी क्लोज आवर दिस वेबिनार, एनीवन एल्स, हमारे जो ऑडियंस है जिन करके हम हैं, बिकॉज आप हो तो हमको मोटिवेशन मिलता है चीजों को ऑर्गेनाइज करने के लिए. यू शेयर योर एक्सपीरियंस रिलेटेड टू रजिस्ट्रेशन प्लान, एनीथिंग which you would like to share with us. Please share with us, firstly. And secondly, if any one of you also want to be a the moderator or maybe a speaker, please convey to us. We shall love to introduce you in our platform. तो ये दो बातों के साथ अगर कोई है तो प्लीज कम फॉरवर्ड. शिवनंदन जी, आपको तो मैंने बुक कर दिया है नेक्स्ट मीटिंग के लिए. आप अनुराधा जी की जगह लोगे और आशीष मुखर्जी हमारे स्पीकर सेम रहेंगे.
थैंक यू सर, थैंक यू.
चलिए, thank you very much. Parveen ji,
Thank
we
you
are
so
able to
much.
hear you.
Yeah.
You please say vote of thanks. Please say your vote of thanks. आई थिंक प्रवीण जी को शायद थोड़ी सी प्रॉब्लम है
परवीन
कम्युनिकेशन
सर का
में।
एक्चुअली शायद स्पीकर बराबर काम नहीं कर रहा है। हाँ
हाँ हाँ हाँ, तो थैंक यू वेरी मच, थैंक्स टू ऑल द ऑडियंस, especially Mr. Mukhija ji or Mr. Atul ji, and I'm seeing the one young Mr. Sandeep Singh ji also there, Mr. Raj Kamal ji, I've seen it many a times there in our earlier webinars also, and the Binder Sethi, R.K. Gupta, Narayan Kama, if I'm missing others' name, thank you very much, thanks a lot. We shall love to see you in our next webinar also, whereas हमने ऑलरेडी मुखीजा जी को बुक कर लिया है, हम आपको कम्युनिकेट कर देंगे कि किस दिन और किस समय है। दैट विल बी शाम के टाइम ही होगा, आफ्टर लंच ही होगा। थैंक यू वेरी मच, थैंक्स फॉर ज्वाइनिंग, थैंक यू।
थैंक यू एवरीवन, थैंक यू सो मच।
Thank you very much, sir. Thank you, sir.
अनुराधा जी आपको भी बहुत बहुत धन्यवाद, आपने बहुत अच्छा कनेक्ट करा है। आई जस्ट
थैंक यू
वांटेड,
सर, थैंक यू सो मच, बट आप मुझे रिप्लेस कर रहे हैं नेक्स्ट में, कोई बात नहीं।
प्रमोट कर रहा हूँ आपको, आपको नेक्स्ट टाइम वो स्पीकर बनाऊंगा।
थैंक यू सर, नो प्रॉब्लम, मजाक कर रही थी मैं।
नहीं नहीं, प्लीज प्लीज।